Pardon to mention on criminal appeal, I have for bail file.
It's may I be permitted to mention item number 17. Today, my learned senior has some difficulty. So, Lordship may have this any other day. I have informed the other side, learned senior Mr. Samin Mishra is appearing. I have informed him.
And item 17 sub-item 1 increment. Yeah.
You are mentioning on whose behalf?
But it's in the first matter, I appear for the discom Tata Power. In the first matter, I appear for the discom.
You are appearing for the
Discom. The electricity licensee, Tata Power. And in the second matter, I am the petitioner.
That is respondent.
Yes, ma'am. In the second matter, I am the petitioner.
In the first matter, you are opposite party number 3.
Yes.
Second matter, you are the petitioner. WPC 27235. What interim order has been passed here?
That no disconnection will be made.
To the first item.
Yes, my lord, first item.
When that order was passed?
28th of February. 28th of February.
There is no such order. The first item is 32308 of 2023. No interim order has been passed.
Well, I'm sorry, well, this is ordered 29th of January. It is an absolute order. Thereafter, it's.
So, has he deposited the amount?
Yes,
Yes, ma'am.
he has deposited and we have not disconnected. We have applied
restored the.
We have restored the power.
All right. Item number 17, the first item. What is your good name?
A. Behra. Arnav Behra.
Mr. Arnav Behra, Land Council, appearing for the opposite party number 3, submits that as per the order dated 29/1/2025 passed by this court in IA number 1343 of 2025, the petitioner has deposited a sum of ₹7 lakhs before the opposite party number 3, and power supply to the petitioner's unit has been restored, and he seeks for an adjournment. The Land Council for the petitioner also doesn't dispute about the restoration of the power supply to the petitioner's unit, and he has no objection to the adjournment prayer made by the Land Council for the opposite party number 3. Does this matter in the commencing from
Any date.
14th of July 2025?
Well, can it be the week of commencing 21st?
21st of July 2021 with WPC number 27235 of 2023. Is there any order passed in 27235?
No, madam.
Okay. All right. Yes.
Application for bail, my lord. You will still.
My lords, may I just mention the matter?
Yes.
My lord has been posted that I'm appearing for that Mahanadi Coalfield Limited. We are the petitioner in the matter. The matter was been listed on 7/5/2025, where your lordship has been posted the matter on 1st July, which is tomorrow. As I've been came to know, my lord is not sitting with the combination. The matter has to, because since it's been scheduled on 1st July, my lord may have it
Yes.
someday. Lord, an attorney general is appearing in that matter, my lords.
Okay.
That is to be then listed on second because a specific bench has been formulated that is to function on Tuesday and Thursday.
My lord, I'm quite aware of that, my lord. That's what.
Those-
My lord, may
those
have it
matters-
on 17th or 18th, whatever is convenient to your lordships.
We will do one thing, let the
Sure.
matter be listed on second and please make a mention so that we can
adjust
take
the
up this
date.
matter. All
Will
those
do.
matters which were directed to be listed on first of, on
Yes,
first
first.
of July 2025 will be listed on second because of that bench. So second, we can adjourn the matter to 70 date which you.
Second is just remind us so that we can adjust
My
it.
lord, we'll do that, my lord.
Okay.
I'm grateful.
Oh,
I'm grateful.
Criminal opted bail.
please give it.
Pardon, mention your lordship, item number 1, on behalf of Mr. Somnath Mehta, your lordship, I am praying for an adjournment.
Wait, let it, yes.
My lords, this is an out of list mentioning. My lords, this matter is to be heard by your
What is
lords.
the matter?
This is a writ petition, my lords. The matter has been delisted. However, the
What is
state
the
has,
prayer in that petition?
my lords, an IA has been filed by the state.
What is the IA? What is the prayer in the petition?
So I do not have the file,
Have it,
my lords.
come tomorrow and make a mention.
My lord.
Day after tomorrow.
Day after
Tomorrow, all right? Yeah.
Read the writ petition.
Just read the writ petition. That is for your benefit, okay? So not mention as such. Just go through the file and make a mention. Yes,
Lordship, item number 1,
just let him call the.
Weekly list item number 1.
may I make a mention, your lordship? I'm appearing on virtually, lordship, where I beg a pardon to appear virtually, lordship, and make the mention. Your lordship, in item number 19, your lordship, we are appearing for the petitioner. We need only 7 days time to file the rejoinder in the same matter. We have obtained consent.
Item number?
19.
19, your lordship. Where for the petitioner, your lordship, we have obtained consent from the opposite party, lordship. Counsel for the opposite party.
Counsel for the opposite party is Mr. Tanmay Mishra.
Yes, your lordship, we have obtained consent from the counsel.
What is your good name, madam?
Ruprekha Jana, your lordship, on behalf of Mr. L.K. Maran.
No, it's all right. We are mentioning the matter.
What is your name, madam?
Ruprekha Jana, your lordship.
Ruprekha Jana.
Ruprekha Jana, Land Council
You
appearing
must
for
write the name there.
Lalit Kumar Moharana submits that senior has received the counter-affidavit filed by the opposite party and intends to file a rejoinder affidavit, and the matter may be taken up. How much time you want for rejoinder?
Your lordship, 7 days time.
For a week. She further submits that she has obtained consent of the London Council for the opposite party for seeking adjournment. In view of the submission, place this matter in the commencing from 14th July 2025. Rejoinder affidavit be filed in the meantime, serving a copy on the London Council for the opposite party. Yes.
Obliged, lordship.
All the matters.
Item 1.
Item 1, your lordship, I am appearing on behalf of Mr. Somnath Mehta, on behalf of the petitioner, your lordship. I'm praying for a short adjournment as Mr. Somnath Mehta had some personal difficulties to appear for the lord.
I've got the opposite party.
No,
Last,
nothing more.
last time also you sought adjournment.
No, your lordship, last time.
As prayer by Mr. Nando, Land Council party petitioner, put up this matter on 13th.
So what is the matter? What is the matter?
About the petitioner is praying for an ample amount of time to repay the.
No, if you are challenging an auction sale notice,
And also praying for time to repay the amount of issue.
no. What is your brief? You see, prayer number 1 was the auction sale which has been carried out. So that means a third party right has been created and you have implicated that third party as Prabhasini Panda. So in view of number of decision, whether this court can entertain such a petition or you have to seek alternative remedy before the DRT. Auction sale has already been completed and third party right has been created. You have implicated that party. So whatever it may be, you approach that appropriate authority. Why the matter will be kept pending here?
Pass it over, let read and go.
You ask your senior, okay, about this. We are just passing it over.
We are passing it over, just get the brief and I think he is there. You are appearing for petitioner.
Yes, how can
Alternate
it will be maintainable here? The
Two I'll settle.
No, not question of satisfy. You have come, so we dispose of level. The writ petition has been filed with following the way.
What, this is the case, my lord.
Auction sale has already been completed. Third party right has been created in view of the decision.
And no notice has been served before it is custody.
All these things you can, alternate remedies there you can raise. Liberty you are giving.
Liberty is granted.
We are giving the liberty.
Dispose of. Yes, next.
But Mr. Justice violates suspended.
That you can raise there.
Yes, item number.
Item 2.
So my Mr. Justice violated also.
Already, anything you can just raise. We are just saying that alternative remedy is available. Liberty is granted to approve this, just all. Yes, next.
Item 2.
In item 2, your lordship, I have just now serving copy to my learned senior.
Be a little louder here.
Is serving a
Yes,
copy.
serving copy to my learned senior. I am praying for next one.
Copy of what?
Extra.
Copy of what you are supplying? Writ petition copy.
Now, Mr. Balkrishnan, what is the stage now? The e-auction, I think it has, sale notice has been challenged here. What progress has been made?
No, second round of litigation, first round of litigation, and lawsuit directed for filing essay has been filed, that is pending.
About this e-auction sale notice,
That
which
is,
is,
just now I received a copy. But
okay, you just go through because whether that auction sale has been successful,
yes, when
so that he will approach the.
only my lord, I have got the instruction on 18/11/2024, sale certificate has been issued in respect of one of the secured assets which have been sold.
That is Deepak Kumar Das.
Yes,
You
ma'am.
see that opposite party.
Deepak Kumar Das.
So you have to approach the alternative remedy.
Essay is already, and essay number 178 of 2024.
All right, left on.
We will record your statement and
This
dispose.
petition has been filed by so and so. Land counsel for the petitioner has served a copy of the writ petition of Mr. Balkrishna Rao. Land counsel appearing for the opposite parties number 1 and 2, who submits an inspection that auction sale has already been completed. So certificate has been issued in favor of opposite party number 5, Deepak Kumar Das. In view of the state of affairs and in you'll be on our distance.
One of these secured. And this is not earlier reputation and the status of essay which is going.
And he further submits that one essay number 178 of 2023 is also sub judice before the Land and Debts Recovery Tribunal Cutter.
Pursuant to the order passed.
Pursuant to order passed by this court, division bench of this court, dated 16/5/2023 in WPC number 16060 of 2023. So thereafter, this auction sale has been.
Yes, yes, ma'am. During pendency of the essay. I think she has to then amend the.
Yes, yes, yes.
Amend the essay and.
That he has to dispose of next.
Okay.
Item 3.
And number 3.
This matter permitted to withdraw because property is already registered in favor of the auction procedure. I'm not pressing this matter.
File is just a memo.
Yes.
We learned counsel for the petitioner, Mr. Sahoo, Sahu files a memo to not face this application. The memo is taken on record and the petition is disposed of as not first. Yes. So,
Item 4.
Obliged.
The dispute already settled between the petition and the bank miller. Amount is
so, yes, we'll fill memo then. Mr. Outright files a memo that the matter has been amicably settled between the parties and the petitioner doesn't want to face the state petition. Files a memo to that effect. Memo is taken in the report. Petition is disposed of as not present. Please file.
Yes, yes.
Yes.
Item 5.
Item 5, my lord, I am appearing through VC for the opposite parties.
Also, I am the petitioner. Will also permitted to withdraw, which are liberty to oppose the
File a memo. The learned counsel for the petitioner has filed a memo. We withdraw the writ petition. Learned counsel for the opposite party bank is present through virtual mail. Memo is taken on report. The petition is disposed of as not. To oppose the TRT. Other लिखिए जो you want to
Memo लिख दे.
see what is granted so on so. Yes, next.
Item 6.
Challenge action of millers, history must be not disposing and the on the last schedule, officers need to direct the government to take instruction.
कौन आपका पोस्ट लेजर अच्छी
The case is posted with 10/7/2026 and the notice was issued to opposite party and though they are the opposite party not be appear, the paper pollution has been made.
10/7/26. Are you?
No, 10/7/25. Sorry.
26.
I'm sorry.
No. You produce the correct one. You see, it is mentioned as 25. 26.
26 date lines.
No.
I will evaluate.
Acha, we are just mentioning it and
I will file correct.
or you will file today.
Today.
So that we can just pass it over.
Pass it over.
That would be better.
Correct करके दियंतु.
रॉकी नाम
और साइन कर दियंतु काउंटर साइन.
नहीं से आउट 25 डेट करो. We have to adjourn the case to after that date. So yeah, to see that the status of the yes, that is passed over. Yes, next.
Item 7.
The item 7 also same thing like that.
Yes, again CGM Khurda dispose of so and so.
They are giving the
February chi.
11/7 watch. 11/7 they are giving the faro the safe. They are not giving the instruction. They are giving the faro comments. But next page that is mentioned that the
Who the date लिखाई जी?
second.
Acha, now the case stands posted to.
इधर सर.
Acha. Left. The London Council for the State, as per the order dated 17/6/2025, has produced the written instruction received from the Chief Judicial Magistrate from S.J. Khurda, dated 23/6/2025, wherein is mentioned that the case is posted to 11/7/2025 for hearing. The written instruction is taken on record. The matter will listed the 21 of the law would take effect. Is this matter will be commencing from 21st July 2025. The Land Council for the State shall apprise this court about the latest development of the proceeding under section 14 of the Surface Act. Yes.
Item 8.
8, your lordships, on behalf of Mr. Bhagavan Das, I pray may time be taken up for week after your lordship. He has undergone a surgery, so we request you.
Who is undergone surgery? Mr. Das?
Mr. Bhagavan.
Please give your name.
Yes, sir.
So and so appearing for we are
And
getting
for the page.
submit that Mr. Das has undergone on surgery and the matter may be adjourned. Mr. Panigai and counsel appearing for the ICICI Bank has no objection to such submission. Madam, prepare up your phone to.
Any day a week after.
After 14th रे रख ले चलियो. Now you want it 21st. 21st only. 21st of July. Yes.
Item 9.
Petitioner is a trained as a teacher in PhD. No.
Speak little louder.
My lord.
Speak little louder.
Petitioner is a trained as a teacher, my lord. Retired on 31st.
You are challenging the order passed by the Central Administrative
Yes, my
Tribunal.
lord.
17/4/2025 is the order.
Unnecessary, man.
Right. Please come to that.
Yes.
And see your prayer that is mentioned in page number 2 or running page 46.
46, man.
What was your prayer before the
To pass the order dated 3/5/2018, man. Passed by respondent to holding the same is.
what is that order?
That order is granting of selection scale of pay, my lord. That is Annexure 7.
Have you annexed the original application? Have you annexed the counter-affidavit filed by the respondent?
No, man.
File so that it would be better for us to appreciate your submission.
And the entire pleading of before
Entire
the
pleading. After
Right.
counter, he might have filed the Rejoinder, whatever it may be.
Yes, my
The
lord.
entire pleading you give it. What time you require?
One.
One. All right. This petition has been filed by the petitioner, Prasanna Kumar Mangaral, challenging inter alia the order dated 3/5/2018 passed by the opposite party number 2 so and so, and the order dated 17/4/2025 passed by the Central Administrative Tribunal, Cutters Bench, Cutters in OA number 652 of 2021. The Land Council for the petition 6 for an adjournment for 1 week to file the original applications and the entire pleadings before the Central Administrative Tribunal. This matter in the week commencing from 14th of July.
Man.
14th of July 2020. Yes.
Item 10.
My lord, I have already submitted the order with the read copy and annexure. All annexure with the printers.
You are for the petitioner.
Yeah.
So you are appearing for opposite party number 3. So that representation which is stated to have been given.
It is no such representation was filed
I'm
earlier.
saying ଆମେ ଆପଣଙ୍କୁ କହୁଥିଲୁ ଯେ representation ରେ କିଛି proof ନାହିଁ, and he has answered like that because there is no endorsement. You have not filed the postal also. It is just dated 24/4/2025. So once these documents are not there, it is very easy to say then we have not received anything.
But first of all, why should we entertain your writ petition like this?
It's not maintainable against the private finance.
You have converted us to a bank. You gave a representation, we will consider it.
Already given.
Go and approach. This is no only notice is
Now, once they say that they have not received your representation, matter ends there.
we shouldn't entertain.
ସେମାନେ ପାଇଲା ପରେ କହିଲେ ଗ୍ରାଣ୍ଟ ଦଉଛନ୍ତି ଆପଣ।
ଆପଣଙ୍କ ପାଖରେ କିଛି ଡକ୍ୟୁମେଣ୍ଟାରୀ ପ୍ରୁଫ ନାହିଁ। ଆପଣ ଯେହେତୁ ସେଦିନ ସବମିଶନ କଲେ ଆମେ ଏଇ ପ୍ରଶ୍ନ ହିଁ ଆପଣଙ୍କୁ ପଚାରିଥିଲୁ ଯେ ଏଇ ରିପ୍ରେଜେଣ୍ଟେସନଟା ଆପଣ ବ୍ୟାଙ୍କକୁ ଦେଇଛନ୍ତି ବୋଲି ପ୍ରମାଣ କାହିଁ? ଆପଣଙ୍କ ପାଖରେ କିଛି ନାହିଁ। ଆମେ କହିଲୁ ଠିକ ଅଛି, ତାଙ୍କୁ ଗୋଟେ କପି ଦିଅନ୍ତୁ so that at least they will say whether they have received or not. Now they are telling that you have not submitted the representation. So what direction will pass? When the representation has not gone to that, what direction will pass?
ମୁଁ ଗୋଟେ କପି ଦେଇଦେବି ଆଉ ଗୋଟେ
Moreover, only a notice was issued to you. You go and give reply to notice. It is a demand notice. You have paid the money, defaulted. Notice has come.
ଆପଣଙ୍କୁ ଦିଆହେଇଛି ଆପଣଙ୍କ 56,113 ଟଙ୍କା ଅଛି ଆପଣ ବ୍ୟାଙ୍କ ସାଙ୍ଗରେ ନେଗୋସିଏଟ କରିବେ ହାଇକୋର୍ଟ କୁ କଣ ପଳେଇବେ
5/6 ମ୍ୟାଡାମ ନୋଟିସ 10,000 ଟଙ୍କା ଥିଲା ତାପରେ ବଢି 23,000
The writ petition has been sorry the learned counsel for the petitioner has filed a memo to show that the writ petition copy has been served on the bank. Mr. Praveer Kumar Roy and his associates have entered appearance for the bank by filing Wakalatnama, which is taken on record. When he put a pertinent question to the land council for the bank as to whether any such representation as ever in the writ petition, wide annexure 5 has been submitted with the bank for consideration. The land council for the bank on instruction submitted that no such representation has been filed. It appears that notice has been issued to the petitioner or a demand notice has been issued to the petitioner and the petitioner has to approach the bank for settlement. Instead of approaching the bank and all this writ petition is up to the petitioner to approach the bank for amicable settlement of the loan account. Accordingly, the petition is disposed of. Yes. Okay.
Item 11.
Yes.
They have to take a ask them that why they are not granted MSME rate of interest.
From that date.
Yes, ma'am. Yes,
You
ma'am.
got the instruction.
Yes, madam. Your lordship may kindly have a glance at page 7 of my counter-affidavit, paragraph 15. I have consulted.
Just a minute. Counter-affidavit, paragraph
15, madam. I have consulted the same manager. Yes, we got it.
Mr. Mahanti, you have received the copy of the counter.
Yes.
Please come to that paragraph number 15.
That the allegations made in para 3.6 of the writ petition of so and so, it may be submitted here that the petitioners had not furnished the required documents as per RBI guidelines enabling the bank to consider the unit of the petitions under MSME category. Hence, the head office of bank by letter dated 1/2008 requested to furnish the required information of such consideration. Now, I am inviting my lord's kind notice to annexure 6 of the writ petition. That letter my lord senior has annexed.
Just a minute. Wait. Sorry. Yes, what do you want to refer?
Annexure 6, page 30 of the writ petition.
Page 30.
That letter which I have read out, that has been annexed to the writ petition.
Okay.
My paragraph point number 1. As per extent of RBI guidelines, an enterprise engaged in the manufacture or production of preservation of goods and whose investment in plant and machinery, original cost so and so, is more than rupees 5 crore but doesn't exceed rupees 10 crores, shall be classified as medium so and so. Last two, a copy of notification showing the details of items to be excluded while calculating the investment in plant and machinery is enclosed herewith for your perusal. Please submit 3-page reference note with audited balance sheet as dated 31/3/2008, latest provisional balance sheet so and so. This has not been submitted. Accordingly, I have replied in paragraph 15, my lord. My respectful submission. The petitioner will be directed to furnish all the documents.
No, it is your
Next
case
letter.
is it your case that since 2008 you have
When I 1/12/2008, they have written this letter.
Yes.
And they have sanctioned this on 6/1/2009 after compliance.
Yes.
They have sanctioned it. Whether has your lordship got annexed?
Next annexure.
interest commission, BML per 12%, BML per 12% as applicable to brief pass rated MSME.
You have written category MSME.
So in
It is your own letter.
this is in the
Just see,
this one.
take Annexure 7, just see.
Annexure 7.
Category you have written MSME. Why
Yes.
do you doubt now?
This is the
No.
letter dated 2009,
9.
2009 after.
My lord, this,
That is dated, my lord, your lordship will see 6/1/2009.
We are pointing out to him.
yes, ma'am. These are sanction letters already. Last day I am making submission. My responsible submission. The petitioner has accepted all the terms and conditions as per the sanction letter.
Okay.
So my responsible submission, as per Annexure 6, my lord, relevant documents previous years from 2000, what is claiming by the petition from 2004 to 2008, those relevant documents are not been furnished. So they submit.
No, no, but he says from 2006 onwards, when the notification came,
yes,
bringing MSME
Yes, yes.
Act into force.
yes,
From that day onwards, you give it. That's what he
Yes.
says. Are you interested? Will you give it?
From 2009, there is no problem.
my lord,
Because you have already granted it.
my lord,
Question is that whether he is entitled for that period
my lord.
from 2006 to 2009 January.
Yes, yes,
So
ma'am.
5/1/2009 per
Again, again.
Whether that is the crux of the matter.
Yes, that is my instruction, my lord. I have stated in para 15 of my counter affidavit, the application, the requirement as per Annexure 6 were not furnished before the what bank.
But you have no problem giving that benefit.
Eh,
Subject to furnishing document. That's what you are saying.
my lord, bank will,
Then what
Michael,
Mr. Counsel, what documents were filed before you for which you gave relief from 6/1/2009?
yes,
If the
my lord.
documents were not filed before you, how did you give that relief which the petitioner wanted from 6/1/2009?
This Annexure 7, my lord, is the sanction letter of the year, my lord, 2009, my lord.
Yes.
No, Skip, kindly appreciate one thing. To Annexure 6, you are saying
My lord.
that you have to give audited accounts only to see whether it is within 5 crore to 10 crore, within that or not. That's what
Yes,
you want to
yes, my lord.
In 2009, you yourself have admitted that it is an MSME.
Yes, yes, my lord.
Once you have admitted that it is MSME, then it
previous-
suffice for the previous year also.
This point I have not ascertained. This is my responsibility, sir.
That is-
Perhaps the loan amount has been enhanced.
Yeah,
This year, 2009, perhaps it has been enhanced.
Oh, you are not taking that stand in the counter affidavit.
No, ma'am,
Can you?
no.
So, that is the
Only-
crux of the matter.
Yes, only paragraph
You are
50.
taking something in your counter affidavit, making some other submission during course of argument. So,
I am confining to my.
accept such, once you are not taking that stand in the counter affidavit, and it's not a point of law, it's a factual aspect.
May kindly have a glance to page 20, that will settle the issue. Page 20, Annexure 1.
That's one, huh?
Yes. This is a letter I asked to the senior branch manager, Andhra Bangalore. Has it also got it?
Annexure 1.
Yes.
Yeah,
Page 20.
yeah,
Has it also got it?
yeah.
Unit can be considered as SME.
So I have furnished all. We have submitted here with chartered accountant certificate regarding investment made in plant and machinery, omitting such items like pollution control equipments, electrification and cabling, transferring incidents. We are requested to kindly process the above.
Mr. Ponda, you have to seek further instruction. All the documents are there. Why to complicate?
No,
Entitled, not entitled. Why unnecessary?
And if you say,
That is
let us say we accept your submission, let us say that he is not entitled from 2006 to 2009, January. You must say that and what is the reason for that? So that he will also get an opportunity to file the rejoinder affidavit. That is not your stand in your counter affidavit.
Only my stand में two-fold.
Our college a document देना थी. Document तो दे.
Did a stand.
Let them file an affidavit.
Para 15, as per the letter, letter under Annexure 6.
Please take proper instruction, file
And file an affidavit.
place affidavit.
Tell the senior officer should file it.
Follow that what he wants. Why he would not be given the relief from 2006 to 2009. From 2009 January you have given. From 2006 the act came and is entitled to get that, provided that he comes within so and so category. You require some documents have already been
State
filed.
document in
So
2008.
why you are giving from 2009, why not from 2006?
Subject to my lord's acceptance, may I suggest one thing? Your lordship can dispose of with the direction of the bank.
ପୁଣି ତାକୁ ଆସିବାକୁ ପଡିବ ଆପଣ ପୁଣି
ଆଉ another writ petition.
No, if in fact, as per the
why are you not taking instruction?
lingering
ଆପଣଙ୍କର ଇଏ ଯୋଉ lingering.
I am breaking my head.
You senior officer should file an affidavit stating all these things. We will dispose it
again.
within 1 week.
Again. I answered 7 times, it will be disposed of then.
No.
Because subsequently it has been granted.
ଏଇ ଟାଇପର ଅର୍ଡର ପାସ୍ କଲା ବେଳକୁ ସେ ପୁଣି ଯିବେ ଆପଣ ପୁଣି ମନା କରିବେ. 2013 ରିଟ୍ ପିଟିସନ.
Your lordship, can you reflect in the order so that I will give instruction to bank.
And they are not telling what is the Reserve Bank rate of interest.
There is small issue now.
If they say that whatever we have charged, that was the prevailing rate of interest, I have no case.
What is talking to the
the learned counsel for the Union Bank of India, Mr. Panda, during course of argument, pointed out to paragraph number 15 of the counter-affidavit, wherein it is stated as follows, quote paragraph number 15. The learned counsel submits that since the required information as per the later dated 1/12/2018 issued by the bank under annexure 6 to the writ petition have not been furnished. That is the reason why the petitioner's case could not be considered. So, on the other hand, Mr. Ashok Mahanti, senior advocate, pointed out to annexure 7, which is the later issued by the bank dated 6/1/2009, sanctioning that is the sanction of the competent authority for renewal, oblique enhancement of the credit facilities with certain terms and conditions. The Land Council further submits that all the required documents are sought for by the bank have already been submitted, and as such, the later has been issued under annexure 7.
Petitioner has been categorized as
wherein the petitioner has been categorized as MSME, and that is the reason why the relief has been granted from 2009, but no reason has been assigned as to why it was not granted from 2006. After perusal of the counter affidavit, we find that no specific reason has been assigned denying the relief sought for by the petitioner to consider his case to grant the relief from 2006 onwards. Let a specific affidavit to that effect be filed by the bank within a week by a responsible officer put up this matter in week commencing from 14th of July 2025. Yes.
May I pray, Mr.
Yeah.
Make a reference to annexure 1. That is the data dated 2006 when I have given the chartered accountants.
Audit. Mr. Mahanti also referred to annexure 1, which is the later dated 16/1/2006, which shows that the chartered accountant certificate regarding investment made in plant and machinery, omitting items like pollution control equipment, electrification, and so on. So it has been submitted before the bank. Substantial, no? All right.
Item 12.
And for the bank,
12, my lord, on behalf of senior advocate Mr. Ramakant Nath, may I pay for next week? He's on his legs, my lord.
you are challenging the order of the DRT.
DRT.
What order was passed by the DRT?
Petitioners challenged the sale notice and sale certificate before the DRT cutter, and it was allowed. SBI went in appeal, my lord, before the DRT. DRT reversed that order of the DRT cutter. Hence, the petitioners are before your lordship.
Now the matter has been remanded back to the DRT.
No, my lord. No, my lord.
Simply set aside.
Set aside. Set aside.
Achha. So you are challenging that order.
They are challenging. No, I am from the bank.
You are mean
bank challenged.
They are the borrower. The borrower has challenged.
Stay is operating.
Yes, my lord.
So you want it next week or what?
Next week, my lord.
No further adjournment. See, 12 adjournment you have taken. I've counted.
Next week, any day.
The interim order was passed and
9th of
9/12/2019. Thereafter, 12 time adjournment has been solved.
It's on his legs, my lord.
Put an end to it now.
Next week, any date, my lord.
No, we are there. We have no objection, but you are enjoying the benefit of the interim order. So
Let's start imposing costs
The
now.
property has been sold, minutes, and third party interest has been created. And the purchaser is in possession of the property.
Any date next week, my lord.
The last and final opportunity if at all. 12.
all right,
More.
you, what is your good name?
Aditya Mahanti, sir.
Mr. Aditya Mahanti.
Yes, ma'am.
Land Council appearing for the Mr. Ramakant Mahanti, senior advocate. Land Council for the petitioner. 6 for an adjournment till next week. The Land Council for the bank as well as Land Council for the auction purchases are present. And Mr. Udgata, Land Council for the bank submits that the sale certificate has been issued in favor of opposite party number
5.
auction purchaser, opposite party number 5.
And sale deed has also been executed.
Sale deed has been executed, and the opposite party number 5 is in
Possession of them.
over the property in question. Stop. List this matter in the week commencing from 7th July 2025. It is made clear that no further adjournment shall be granted. Yes.
Obliged.
Item 13.
Permission, item 6, they have already gone it actually later.
अच्छा दियो ना item 6 टा देखो. Call item 6.
Pass over item number 6.
25 only, na?
The Land and Council for the state has produced the letter dated 36/2025 of the Deputy Collector from our judicial, which indicates that Mistress number 50 of 2023 under section 14 of the Surface Act is now posted to 10/7/2025. The letter is taken on record. The matter will be listed in the week commencing 21 21st it was 21st of July 2025. The Land Council for the state shall apprise the scope about the development, if any, made in the meantime. Yeah.
Item 13.
Your lordship, I humbly pray for taxes.
You are for whom?
Petitioner.
Oh, partially.
Item 14.
Sir, kindly see the last order. Order dated 7/5/2025.
Yes, opposite parties number 2 to 5 were directed to file an affidavit with regard to the shifting of this one.
Next date.
Now that affidavit, on that date, that the was directed to file an affidavit with regard to the CA regulation, the provision of the CA regulation. In fact, that was the direction on open court. Subsequently, we found that my friend was there, or my senior was also there. That CA regulations of a provision of shifting of poles and 11 kV line is concerned. That is, with that regard, I have filed my affidavit.
In that regard?
I have filed my affidavit.
Where is that?
That is on filed on 25/6/2025. I have supported also copy to my
Regarding shifting.
with regard to provision of the CA regular CA installation regulation.
Direction was to file an affidavit regarding shifting.
Shifting. Subsequently, the open court it was directed that
Don't say. We have to see the order. Then you move application before that court. Open court, what had happened?
My submission, that direction also attains the finality of the entire writ, your lordship. I have raised the point of maintainability of the writ petition.
Something which is not there on the judicial record.
There is a judicial order has been passed. If you say that it has been incorrectly reflected, then you should file an application and it is to go to that bench. Because after hearing both of you, an order has been passed that when you will shift it. That was the order. Now you are justifying that 11 kV line has been correctly taken. That is not the thing. On that day, as seems that you said that now I will take to shift that. On the private land, over the private land, you have taken the 11 kV line.
Yes.
So there is some procedure, the rule is to be followed that how you will take the 11. If it requires that it is to be taken on a private land, then what is to be done? Okay. So you cannot take anybody's land or house in 11 kV line. So question is that on that day when you made such a submission and an order has been passed, now you are backing it out. That no, I have not said so. Bring it by file an affidavit to that.
This rule also not applicable. This rule has been quoted in the order.
Whatever it may be.
Well, on the my submission, we raised the point of maintainability. So far, also the point there was that on the roster point, it is matter pertaining to the single bench. So that order of GRF and ombudsman that has not been challenged here in this reflection. That was
the registry has stated that it's a division bench matter. It was also listed before the division bench on several occasions, and you have never said that no, it is not a division bench matter, it's a single bench matter. So you are changing your stand from time to time.
Last occasion also said by
no. Sir, this is 8th hearing. And the first matter was listed in 2022.
I have no objection subject to lordship.
No, that's not the issue. If you are saying something, you bring on record by moving an application. Then we can deliberate upon that. Something which is not there on the record, on the 8th hearing, you are saying that it should have gone to single judge, and you have wasted the 7th hearing of division bench. Then, in the first day, you should have done it.
I'll file necessary application.
2022, I am not able to construct me. Hospital is concerned. Thereafter, they have staged
the matter was heard by the then the Honorable Chief Justice.
Yes.
So many hearings taken.
But they are quoting the rules not applicable even me.
We can call the authority here, personal authority. So all those things we can do it, but since
see the photograph lot after construction.
No, there is no they are not disputing that it has been taken on the private land on your private land. So
let's keep it some other day. I'll take us.
Because some,
You know that once you have taken the line, if you want to change it, there was to be a huge investment also in that way.
and
Because the entire thing, no.
because
it is
she
up
was
to you.
agree to
So-
bear the cost.
No, I never agreed.
You
Never
also
agreed.
kind of glass the age
No, I never agreed.
11 kV ଲାଇନ ଟାକୁ ଗୋଟେ ନିଆ ହେଇଯାଇଛି ତାକୁ ଆଉ ଗୋଟେ ବାଟ ଦେଇକି ନବା ପାଇଁ ତାର ମାନେ ଯୋଉ କନଷ୍ଟ୍ରକ୍ସନ କରିବାକୁ ପଡିବ ଇଟ୍ ୱିଲ୍ ବି ହ୍ୟୁଜ ଇନଭେଷ୍ଟମେଣ୍ଟ ତେଣୁ ଆପଣ
See, I'm
Petrol
shift to
charge
payment.
And that is subsequent after they have built up the house, subsequent after the erection.
କଣ
After election, can it be passed immediately?
Build up their building subsequent after the
Sensible
erection.
person can build a house.
And you'll also kind of glass their annexer will also kind of.
No, we are not entering into. So you change it, bear the or pay compensation, whatever. 11 kV line, he cannot sleep comfortably. If he will go to the top of the building, we don't know what will happen.
In fact, suppose compensation will also under section 16.
Or it is like a Damocles sword hanging on somebody's head.
You'll also
11 kV line ତା ଛାତ ଉପରେ ଯାଇଥିବ ତା ଘର ଉପରେ so କାଲି ଛିଣ୍ଡିଯିବ ତା ଅବସ୍ଥା କଣ ହବ?
So bottom to 11 kV also insulated air, insulated.
ଆପଣ
I understand you also. And so far compensation is gone, my senior is agree. Let the file an application before the collector that is under section 16(3).
That you negotiate between
Need to
yourselves.
see it first.
We are on a specific order where a direction has been given that you file an affidavit with regard to the shifting of the same. How you will shift, when you will shift, that is the cross of the matter. Now, if you change the stand, then we'll be compelled to pass another order. So take proper instruction and file.
Allow me 10 days
So
time.
the affidavit has been filed by the petitioner, opposite party number 2 to 5 on केवल फाइल कर देंगे affidavit
25/6/2020.
कहीं से ऑर्डर का कहीं on 22/6/2025 and copy of the affidavit has been served on the learned counsel for the petitioner, but we find that there is nothing in it regarding the shifting of the 11 kV line which was taken over the private land of the petitioner. The learned counsel for the opposite party number 2 to 5 seeks some further time to obtain proper instruction in the matter. Put up this matter, we commencing from
14th. We commencing.
Okay, 14. Mr. Patna, Satpati Land Council for the petition is present for them. 14/7/2025. Yes.
Item 15.
In this matter, the petitioner is challenging the order of the opposite party number 2, wherein there's a direction for forfeiture of the security deposit and blacklisting for 3 years. If I may just hand over the list of dates to your lordship.
Come to the impugn order, let us see.
Yes.
Somebody is appearing for the
Opposite parties
opposite
2 and
party.
3.
You are appearing, but what about opening one?
Number 1
It's not a contesting part.
No. You are challenging the
Order dated 9/3/2023, which is at page 32.
That is annexure 1.
Yes.
Which part is hurting you?
But the last part, which starts from page 33.
yeah.
Therefore, in exercise of the power conferred under clause number 7(4) and 9(f), which speaks in the event so and so, I'll take your lordship to that tender. But if your lordship will look at the last paragraph, the contract is hereby summarily terminated with immediate effect, besides forfeiture of earnest money and security deposit, and the corporation shall proceed for appointment of another contractor at the risk and cost of the terminated contractor, that is Sri N.K. Pathak, any losses or damages arising out of the same and incurred by the corporation due to conduct of Sri N.K. Pathak would be recovered from Sri N.K. Pathak without prejudice to any rights and remedies available to the corporation under the contract and law of the land. The tenderer so-and-so is also debarred from participating in any future tenders of the corporation for a period of 3 years. Now, there are two limbs of this. One, the forfeiture of the security deposit. And
No, why such a drastic step was taken again?
I'll just tell you, Lordship. I applied in the tender under the experienced category. There was an inexperienced category. There was nothing in the tender which showed that if you do not qualify in the experienced category, we will declare you as a successful bidder in the inexperienced category. What they did was they put me in the inexperienced category, declared me as the L1 bidder. But when they issued the notice to me stating that I am declared as the L1 bidder, nowhere it was mentioned that I am in the inexperienced category. Under the inexperienced category, I have to pay a 10% extra amount of security deposit by way of a back guarantee. I sought for a clarification. For the first time in the clarification, they said that you are under the inexperienced category. I said that I have applied under the experienced category. So either you reject my application that no, you do not fit into the experienced category. You put me in the
bring it to inexperienced
category and say that you are not complying with the inexperienced category, the formula which has been given in the tender document, and therefore we are enforcing this, and then blacklist me, and then forfeit my earnest money.
So as
that's the short issue here.
So as that you have applied for in the experience category.
Yes, sir.
And that particular clause in that tender.
If your Lordship will first look at the clause in the tender.
Yes,
that's at page 57. It starts at page 49, and the relevant portion is at page 57.
57.
Yeah. 3. Qualification conditions of tender.
Yeah.
The Lordship has it.
57.
Qualification conditions.
Yes.
The first one and Roman 1 and Roman 2 are under the experienced categories. Roman 3 is the inexperienced category.
Read it.
Tenderer should have experience of rate handling and or transportation and shall be related to rate movement only, duly obtained from manufacturer, PSU, government department, public limited company, private limited company dealing in the field of fertilizer, food grains, cement, sugar, coarse grades, or similar products, so and so. At least 25% of the estimated value of the contract to be awarded in one single contract. 50% of the estimated value of the contract to be awarded in different contracts. In case of partnership, only the experience of the firm will be reckoned, and for the purpose of experience of the individual partners will not be counted. Experience details in the pro forma prescribed that so-and-so shall be furnished by the tenderer. The information furnished in Appendix Roman 6 shall be supported by experience certificate issued by the client. Now, I'll just read it later, Roman 3. If your Lordship will go to page 101, that is the pro forma of my work experience certificate which I had submitted. 101.
Yes.
Now, your Lordship will look, I applied under the experience category and gave them my experience.
Work experience.
And if your Lordship will look, the total value is 57.50 lakhs, which fulfills the criteria as far as Roman 1, A and B is concerned. Because the total value of the entire work order was 67 odd lakhs. Now I have given 57.50.
Right.
Now if your Lordship will go back to 57.
Once again.
Roman 3, where the estimated contract value of handling and transport contract is less than rupees 7 crores and 50 lakhs tender without the requisite experience, as mentioned above, may also participate subject to providing an undertaking that an additional performance guarantee in form bank guarantee of 10% of the contract value from scheduled commercial bank notified by RTI operative will be given if selected. The format guaranteed to be operative so and so, and inexperienced category. And that particular appendix 5 is at page 99. Inexperienced category, page 99 is the pro forma of that. So I did not fill it up because I applied under the experienced category. Now your lordship will look at page. Okay. And if your lordship will now look at page 119.
119.
That is where I was declared as the L1 bidder. And nowhere it is mentioned that I come under the inexperienced category. Except for small Roman 2, which
Yes.
says that you
10%.
but they do not mention inexperienced category. And I paid the amount as an experienced category.
That 10% also you paid.
I paid.
Yes.
Then how do you say that you do not?
No, I did not pay for that 10%. I paid under the experienced category, whatever was required. I paid it.
No,
Under the experienced category.
whether in experience category,
Yes.
A person is required to pay this amount, 10%.
Yes, my lord.
Okay, you have objected that I'm an experienced person, why you paid it?
If your lordship will look at page 59, that is the security deposit.
How much?
I'll just tell you.
Is that 10% only?
Yes, my lord.
That there also 10%, here also 10%.
Yes, my lord. Page 50, page 50. 59, page 59. Yes, my lord. If your lordship will look at page 59, clause 7, security deposit. A and B are the experienced category. A sum equivalent to 5% of the value of the contract submitted electronically through NEFT, so and so other electronic in favor of the general manager, the contractor and his opinion may deposit 50% of the amount in so and so, so and so, so and so. Another sum equivalent to 10% of the value of the contract.
That you deposit.
We have that, yeah. And C is the inexperienced category in page 59, clause 7. This is where it is the inexperienced category.
59.
Page 59, clause 7, subclause C.
Subclause 3.
C.
C, yes, sir.
And it says in terms of if your lordship will look at this subclause C, this is very important. If applicable, an additional sum equivalent to 10% of the value of the contract in addition to any above in terms of an undertaking provided by the tenderer for relaxation of eligibility conditions. This is the inexperienced category. I have given no undertaking when I submitted my bid. No undertaking was given whatsoever. It is only when you give an undertaking, then you are liable to pay. In the form of so and so irrevocable bank guarantee issued by the schedule in the format prescribed under Appendix 5. Appendix 5, I had shown to your lordship at page 99.
Yes.
And no undertaking was given when I applied, when I submitted my bid.
Then what happened?
Look, then I deposited the amount of 1,67,500. The payment was acknowledged by the opposite party number 2, that is Food Corporation of India. Then I sought for a clarification on 22/11/2022, that is at page 124. That why are you charging me?
Yes.
Yes.
And that for the first time on 28/11/2022, they clarified that you have been declared as L1 bidder under the inexperienced category. That is at page 126. And the relevant part is, sorry, this 126 is my letter that why are you doing it? 127 is that clarification. The first paragraph, if your lordship reads, your lordship will get it. The acceptance letter issued so and so, dated so and so. to furnish a sum equivalent to 5% of the value through so and so, a sum of equivalent to 10% of the value under so an additional sum in so and so, being technically qualified as an inexperienced bidder.
Yes. Thereafter, the
Then they issued a show cause. That why your EMD should not be forfeited and you should not be blacklisted. Then I met them personally on 6/2/2023. I said that I have applied under the experienced category. Why are you putting me in the inexperienced category? And if at all, if you find me, no, I'm not in the experienced category.
Reject
then you should have rejected my bid. My technical bid, you could have rejected in the technical round. And then on 9/3/2023, the impugned order is passed.
Yes. Whether they're experienced or inexperienced.
Inexperienced.
He applied for experience and you
He
convert.
never applied for experience, my lords. My lords will see an undertaking. The fact was, let's just expounded right now, there was no undertaking given. My lord may kindly have a look at their undertaking.
Where is that?
My lords. Appendix 1, my lords, page 87 of the writ petition.
87, huh?
My lord. Page 87. Clause 5. I hereby undertake, my lords could get it. Page 87 of the writ petition. Clause 5, the last clause.
87.
I hereby undertake to furnish an additional performance guarantee in the form of a bank guarantee.
Again read it.
My lords, I hereby undertake to furnish an additional performance guarantee in the form of a bank guarantee of 10% of the contract value from scheduled commercial bank notified by RBI, which shall be valid and enforceable till 6 months after the expiry of the contract period for tenders without having the requisite experience.
That 10% is there for experience also.
For
maybe because of that
EMD, my lords, these three, for an inexperienced bidder, there are 3 deposits to be made. 5% EMD, 10% security guarantee, and additional 10% performance. Now, my lords, the tender was opened and the technical bid evaluation report is at page 20 of my counter affidavit. Page 19, annexure B/2, the relevant portion is as page 20. This is the technical bid evaluation report.
Page
Page 19. Page 19, my lord, will come to serial number 3.
Counter-affidavit.
Your counter-affidavit.
Filed by the opposite parties.
Annexure B/2, my lords.
B/2.
My lords. Page 19 of the counter.
299 page.
Right, my lord.
229, it is internal page.
Yes.
Internal page 19.
Yes.
My lords. The serial number 3, my lords, will see that the total value of the contract is 67 lakhs. Page 20, the next page, my lords will see at the bottom of the page, 2 bidders were there. The bidder Bijay Ketan Bhatta has submitted all requisite documents, hence the bidder may be technically qualified as an inexperienced bidder. Serial number 2, the petitioner in this case.
Where
are you?
Page 20, my lords, the last
page 20.
Last part, my lords will see serial number 1. The bidder Bijay Ketan Bhatta submitted all requisite documents and the bidder may be technically qualified as an inexperienced bidder. And serial number 2, the bidder Nankishore Pathak, the present petition, has submitted all requisite documents but has not submitted the copy of VPF registration certificate. However, the party has furnished the VPF deposit challan. Hence, the bidder may be technically qualified as an inexperienced bidder. This is available online from the date it was uploaded, 1/10/2022. So the bidder knows that he has been selected as an inexperienced bidder. After this, he sends a letter. This letter, my lord will find, and in fact, after the bid evaluation report is the letter of acceptance at page 22 of my counter. This is annexure C/2. Annexure C/2, page internal page 22 of my counter, paragraph Roman small 2.
So the three amounts, the first amount is 3,35,000 rupees is EMD. The second amount is 10% of contract value amounting to 6,70,000. The third amount is additional sum equivalent to 10% of value of contract amounting to 6,70,000 rupees as an inexperienced bidder. And the very next page, my lord may kindly come to Annexure D/2H page 23. This is in Hindi, this letter. I'll just read out the relevant part. This is issued on 9/11/2022. The bid evaluation report was submitted on 1/10/2002. This is after he has received the bid evaluation report. He says, my lord may come to paragraph 3. इस विषय में विनम्रता पूर्वक हमारा कहना है कि हमारी प्रतिनिधि द्वारा निविदा में भाग लेते समय भाव देने में भूल हो गई, जबकि प्रतिनिधि को हमारे द्वारा बताया गया था कि 45.77% ASOR is above scheduled rate is equal to 221 rupees 57 पैसे प्रति टन के भाव से निविदा में भाग लेते हेतु कहा गया था, किंतु उनके द्वारा गलती से 45.77 रुपीस भाव दे दिया गया, जो कि आपके अनुसूची दर 38.49% बिलो शेड्यूल ऑफ रेट है, जो कि बाजार भाव से बहुत कम है, जिसमें हमें बहुत भारी नुकसान का सामना करना पड़ेगा. This is the reason why he has never come to.
English translation.
The English translation, my lord, is that he has quoted.
Wrongly quoted this.
He has quoted the value of 45 rupees 77 paisa, which is 38.49% below the schedule rate. He should have quoted 45.77% above the schedule rate. That is his contention. So therefore, if I go ahead with this contract, I will incur heavy losses. Do please reconsider. Now, we are a government agency. There is no scope to reconsider once the bidder has bid as L1. This is not the issue. This is started. And this entire letter does not contain anything about inexperience or experience. The inexperience or experience part comes when he is asked to deposit the security. Then he comes forward and then he says, my lord, in fact, the first time he raises this issue is letter dated at page 121, my lordness, of the writ petition at Annexure 6. Page 121 at Annexure 6.
Yes.
My lord, I'm placing that. With reference to the above cited, I would like to request you to kindly accept my 50% security deposit money against above reference work, so and so, amounting to 1,67,500 rupees from HDFC Bank, branch Darbhanga, to your mentioned account in MTF, and remaining 50% of security deposit money to be adjusted from each admitted bill. 10% until completion of the 100% security deposit money, and we can submit bank guarantee after 15 working days with penalty of 1% of the whole amount of security deposit from any nationalized bank within the time according to MTF through SFS platform to FCI bankers. So he has deposited half of the earnest money. He is saying that you impose a penalty of 1% according to the terms of the contract. And after that, with that penalty, I will pay you the additional security deposit as well as the guarantee. When this was also allowed to him, that yes, you take time, you please pay. He doesn't pay.
Is it your case that they had a knowledge that they have been considered in
yes, my lord.
That is what I
yes, my lord.
Knowledge is something different.
Yes, yes.
Question is whether they have applied for in experienced category or experience category. That is the first. You have to go. You have to cross that hurdle. Knowledge of considering them as an inexperienced category is a subsequent to the tender process. Subsequent to the tender process. We just want to know whether they have applied in the inexperienced category or experienced category. You have to cross through that. Thereafter, the knowledge part comes.
Knowledge is categorically given an undertaking in Appendix 1.
That's the subsequent conduct. You tell us first whether he has applied for experience or non-experience. You answer it. Knowledge is there. It's apparent on record. Knowledge there. He has accepted subsequently. That may be a subsequent conduct. But we must know. You have very categorically, you had two categories. One is experienced category, another is inexperienced category. Somebody is applying for inexperienced category. That's the corruption. You bring him to some other category. How can you do that?
No, no, my lords.
The entire process vitiates.
He has never.
Therefore, the entire tender process vitiates.
He has never.
Forget about the subsequent tender process.
He has never applied under the experience category. Number one, my lord. Secondly, my lords.
Inexperience category.
Yes, yes.
How do you say so, Mr. Nayak? How do you say so?
My lords, while applying, my lord, he has signed a contract. He has in fact given an undertaking saying that I hereby undertake to furnish an additional performance guarantee. Otherwise, he would not have given the undertaking.
So that is a subsequent. The entire tender process is vitiated. We will have to quash the entire tenders. Go by fresh tender, do whatever.
Well, I must respectfully submit that the tender was never given effect to. As such, the tender, even the second party never came up with.
We are not saying that they are also clean. All of are mixed up. Your officers and all of them are mixed up. Now you justify in the court. They will also try to justify, you will also try to justify. But the fact remains, the tender process is vitiated.
So, notice inviting tender is very clear, my lords. At page 18 of my counter, the NIT is there. Page 18.
Why don't you answer whether experience or inexperience?
The inexperience, my lord. It's in inexperienced category, my lord.
Show their application. It starts from there.
The application itself, my lord, as I am submitting before my lords, humbly my lords, the application itself contains an undertaking. Otherwise, you would not have signed that undertaking.
At page 41.
87, his sign is there. He signed it.
The Lordship will look at
Forwarding
serial
letter.
number 6. Serial number 6 is experience issued by the Divisional Manager, Food Corporation of India, Divisional Office, High Court of Orissa, amounting to rupees 57.50 lakh. And that is where 101 is the format. This is the appendix number 6, where I filed under the experience category. There is another appendix which I showed to your lordship, which is with regard to inexperience category, which remains unfilled. My learned friend is relying upon one letter, but is not explaining page 101. My learned friend is duty bound to explain 101, whether I applied under the experience category or not. This is appendix 6.
101.
You come to page appendix 1, page 41. F13. EPF deposit challan against the experience period. All these things are required for inexperience category. You should have rejected the application straight away.
No, my lord,
instead of rejecting the application, you entertain and then try to justify.
No,
because they are mixed up.
This experience certificate that he has given, this is of the FCI itself. My lord will now come to the relevant clause of the contract, my lords. Page 57. I will take my lords again to page 57 of the writ petition. My lords may come to qualification conditions for tender. The note that is in that clause, my lords. Note. In bold. Page 57.
57.
No. For handling contracts, the experience of only handling is mandatory.
1 minute. Yes. 3.
1.
Clause 3, qualification conditions of tender, and the note appended to that qualification conditions. The note below in bold.
No. Yes.
For handling contracts, the experience of only handling is mandatory.
57. Roman 4.
Below Roman 4.
Yes,
For handling contracts, the experience of only handling is mandatory, and for transportation contracts, experience of only transportation is mandatory. For handling and transport contracts, experience of either handling or transport or both in respect of rake only said because this is a handling contract. This is purely a handling contract. So only handling contract experience is mandatory. Now, my lords, clause 2 says the year for the purpose of experience will be taken as financial year, excluding the financial year in which the tender inquiry is floated.
Yes.
So his experience has to be 25% because he has given only one experience certificate of one contract.
You should have rejected.
No, my lords, because he directly falls into the inexperience category because of this reason. The NIT clearly says, I was taking my lords to the notice inviting tender. This is page 18. As the tender value is less than 7.5 crores, the page 18 of my counter.
18 morning.
Well,
Yes.
as the tender value is less than 7.5 crores, the tenderer without requisite experience as mentioned in the tender document may also participate in the tender subject to providing an undertaking that an additional performance guarantee of 10% of the contract value in the form of irrevocable and unconditional bank guarantee issued by scheduled commercial bank notified by RBI through SFMS platform to the FCI banker as per MTF clause number 7(6) under general information printed will be given along with SD if selected. So he has given an additional performance bank guarantee, which I showed to my lords. So automatically, my lords, we considered his tender under the inexperienced category. Now that 25% value that is showing my lords, where coming back to page 57, that note that I was pointing out to my lords, my lord will see that the experience certificate that has been tendered is for a total value of 57 lakhs. Out of 57 lakhs, I'll take my lords to the clarification that I asked for from our office. This is at G/2, page 27. The experience certificate that he has given, my lord, says for work that included both handling as well as transport. That note that I was just pointing out to my lordships very clearly says that this is a handling contract. So the experience only for handling part will be considered. Now that clarification we received from our own office because that tender that he has pointed out is of the FCI work only. So as page 27, annexed to G/2, my lords may kindly have a look at the clarification.
In the tender document, is there any clause pertaining to the leverage given to the department to convert it from experience to unexperienced, irrespective of whatever in whichever category he has applied?
He hasn't.
Do you have any leverage so that you can convert it?
There is no specific clause there, my lords. There is no. What I am trying to humbly submit with my lords says that when the notice inviting tender, as I was pointing to my lords, as page 18 of my counter is very clear that for contracts below 7.5 crores, an inexperienced bidder may apply. And if he applies, he has to give an undertaking. So once he has given an undertaking in the application form, our presumption is that he is applied under the inexperienced category. That became clearer when we asked for a clarification on the experience certificate he had provided. That experience certificate, my lords, will be at page 26, annexure F/2. Annexure F/2 of my counter. My lords could get it, man. Annexure F/2 at page 26 of my counter. This is the experience certificate that he had given. $1.5 lakhs, the experience certificate.
Is that last or that he is not filled up to the inexperienced category?
Well, that form that was pointed out, my lords, with great respect, it's only a bank guarantee format, which he has undertaken to provide as per his undertaking later, which is now saying that I will not give you because I submitted under experience. Now, if his contention was that he was experienced, he would have said it from the very beginning instead of sending a letter which says, look, I have quoted a figure by mistake.
Common form.
Okay.
PA ପାଇଁ fill up କରିପାରିବ, P.Com ପାଇଁ କରିବ, BSc.
Again.
ପିଲା BSc part ଟାକୁ fill up କଲେ, ପୁଣି apply କଲେ। ଆପଣ ଦେଖିଲେ BSc fill up କଲେ, ତାକୁ ଆପଣ admission issue କଲେ, ତ ତାକୁ କଣ ଭାବିବ? BSc ଆସିଲା
ମୋ କହିବା କଥା ଯଦି if that
You are not an experienced person. How can you on your own say that you are inexperienced
I'll clarify. जो certificate है सिर्फ यही चाहिए.
The tender paper is supported by the documents which is required to be filed by an experienced person. Not that he has not filed experience certificate. The experience certificate is high virtually for experienced persons for filing group fill ups similar fill up leaving those columns back so which are applicable to inexperienced person.
नहीं तो करनी सेटा जो जोटा appendix 6 टा जोटा that was shown to my lords. Appendix 6 टा my lords.
Page 99.
Just so that the inexperienced person would have gone to this.
Yes, sir. Page 99.
99 टा my lords will see it's the format of a bank guarantee. 99 भी fill up है नहीं तब पूर्व जोटा.
But probably if your lordship looks at page 131, that will seal everything. My learned friend says that I applied under the inexperienced category. Just have a look at page 131. That is their own letter. Page 131.
Annexure 14.
Annexure 14. Annexure 14, page 131. This is addressed to me. Just see point number 4. That this office sought for clarification from DO Berhampur regarding the amount of handling work executed so and so. It is clear that you have done handling work of so and so for the final vessel, whereas the value of the contract is 67 lakhs. If you think that this is, I have come under the inexperienced category, this itself shows that I applied under the experienced category. You made an inquiry, you found that I am not experienced. You reject my bid.
My lord, that is being that's not a statement. That is not a statement.
Letter is addressed to me.
That letter has been addressed to him because he insists that I applied on the experience. Therefore, it was clarified like, look, you never applied on the experience category because thrice 4 times after saying that I have made a mistake and then saying that I will deposit the performance guarantee with penalty, which was allowed to him. He came back and said that, look,
subsequent paragraph also.
I'll have to complete, my sir.
You have been qualified as in DOP above, therefore you have been qualified in the inexperienced.
Because there are 4 letters preceding this letter that has been issued to him, where he is consistently saying, twice after he has said,
in view of the above, you have been treated as an inexperienced.
Yes.
He had applied for it.
No, my lord, that proforma 6, my lord, that was pointed out at page 101 is only the proforma for how an experience certificate is to be given. This is if I am giving a certificate of my experience, in what format I should give it. That's the proforma that is page 101. So what is being clarified to him that your experience certificate that you were given in the proforma under page 101 entitles you to be an inexperienced bidder. Why an inexperienced bidder? Because the handling work that you had undertaken during financial year 21-22 is less than 25% of the contract value, which is why that was explained to him, you are inexperienced. Now, my humble submission with my lords is this. Had he not known that he was under inexperience, the first letter that he sent out when the bid evaluation report was made online, which I was showing to my lords, where he was very clearly written that you are inexperienced, he would have said that I am inexperienced, reject my bid. He hasn't said that. The first 2 letters were basically saying that, look, I have made a mistake, you please revise the quotes. The second letter said that I will pay the amount with a penalty of 1%. My lord, technical bid is...
That's why you don't know whether he has applied for experienced category or inexperienced category. The technical bid was open. Thereafter, all this correspondence, you knew this, you knew that, all these things. The fact is then the entire bidding process is covered PG.
My lord, he has understood very clearly.
Whether he's experienced or not.
My lord, It's only when we look at the experience certificate can we know we've looked at the experience certificate, and that's on the basis of that we have declared him. No, because there is a clause for considering somebody inexperienced. He isn't saying whether I'm inexperienced or experienced. He has given an undertaking saying I'm an inexperienced bidder. So we'll proceed as if he's an inexperienced bidder. That's what we have done. And he never
was
said.
so indispensable that either in the category of experience or inexperience, we have to consider him only.
Lord, we have to move food grains. This is food security.
But what reason? For what best reason? He is the only indispensable person.
No, my lord, 2-year bid, he bid the lowest. My reason is a tender, he bid the lowest amount. Now he comes back and says that, look, I made a quotation by mistake. He is quoting 38% below schedule of rate. As a government entity, we are bound to give that tender to him. But we have no option. And further, my lords, we went into merit, so I did not object on maintainability. My lords, the order itself, the counter affidavit, the order itself, my lord will see that was pointed out as page 33 of the writ petition. May my lords again place that order? On how and on what condition that bid security deposit was forfeited?
What is the amount?
The amount, my lords, is 6,70,000 rupees. Guarantee. Therefore, in exercise, my lords, I'm going.
Why don't you reconsider the blacklisting part?
Blacklisting part.
And forget about that money. Blacklisting you recall. As simple as that.
1 year only is left anyway. After the 3 years,
blacklisting, you recall blacklisting and the forfeit.
Well, my submission, my lord, may kindly recall for obvious reasons. On maintainability aspect, I was pointing out to my lords. Why not maintainable? I'll just clarify, then my friend can speak. My lord, this order very clearly says under what powers this order has been passed. Therefore, in exercise of the powers conferred under clause number 7, 4, and 9F. And clause 13 of the contract. This is not an exercise of a statutory power or a quasi-statutory power. This is purely an exercise of power under the terms of the contract. And there's a long line of decisions from 77 from Agarwal versus State of Bihar, saying that if a power is not statutorily exercised and it's a contractual matter, then my lords, under 226, this petition is not.
Yes, proceed then.
That's a very clear proposition. I have never said anywhere that I have forfeited your security deposit because I am exercising a statutory power or a quasi-statutory power. No. Very clearly, my order reflects where and how I have forfeited. And this is clearly under the conditions of the contract itself. So therefore, my lord, my humble submission, this is not entertaining. My lord, I'll just want those decisions.
Consideration of that blacklisting part.
I'll do that. I'll kindly in the meantime just.
It's all right. We will take up the matter.
There are contrary judgments also.
May I just.
Look, statutory power, my lord. No, I'll not press upon that point. It's very clear.
If your lordship will permit me, I have just 2-3 sentences to put forth. The first is, this is not a challenge to the contract. This is a challenge to my blacklisting.
Okay, that is why
blacklisting goes to the root of it. And there are plenty of judgments of the Supreme Court.
Daffodil.
Yes. And I must tell your lordship that if your lordship will look at page 101, my learned friend calls it a format. It's not a format. I've filled it up.
Okay.
It's by handwriting.
Let him get the instruction.
This petition has been filed by the petitioner challenging inter alia the order dated 9/3/2023 passed by the opposite party number 2, Food Corporation of India, regional office, so and so, represented through its general manager, in passing an order that the petitioner, the tenderer is debarred from participating in any future tenders of the corporations for a period of 3 years from the date of issuance of the order under the clause 7, 4, and 9F of MTF, that is page number 34, last 3 lines. After hearing the learned counsel for the petitioner, we suggested the learned counsel for the opposite party wants to obtain instruction if the opposite party too can consider about the blacklisting part and to file an affidavit in that respect. Put up this matter in the week commencing from 7th of July 2025.
Can I say that your lordship will fix the matter on the 5th of July?
Sir?
Because your lordship has that NCL matter also listed on 25th.
25th July.
25th.
Please this matter as 25th of July 2025. Yes, next.
Very gracious.
When you start attacking on the ground of maintainability, then your case on merit is shaky. That's what you perceive.
I would have gone to maintainability straight away because my lodge posted question, I went to the.
It is a lighter side. See.
So let us come. We are just take after 2 minutes we are done.
Item 16.
Item 16, madam, I mean VC, madam, sorry. Here what happened, pursuant to notice, the other side has entered appearance and filed 2 counter affidavits, madam. Let him gotte counter rakhi, let him withdraw another counter so that I am able to file the rejoinder, because one counter contains 13 pages, another counter contains 123 pages.
I am filing the memo, my lord. Wrongly filed first one, may please be.
First counter means it has been filed on one date or 2 dates? ଗୋଟିଏ ଦିନରେ ଫାଇଲ କଲେ ନା ଗୋଟେ ଦିନ ଫାଇଲ କରିଛନ୍ତି?
ମାନେ ଅଲଗା ଫାଇଲ ଅଛି ପ୍ରଥମେ ଏଟା ଯୋଉଟା ଫାର୍ଷ୍ଟ ଫାଇଲ 18 ପି
that is exactly just
ଗୋଟେ ଫାଇଲ କଲେ ଆପଣ
first counter ଟା କେବେ ଫାଇଲ ହେଲା?
18 3 24
wait 18 3 24 ସେକେଣ୍ଡ ଟା
ଠିକ ଅଛି
ସେକେଣ୍ଡ ଟା ଫାଇଲ ହେଇଛି ଓଡ଼ିଆ 24
so you want to not press or what you want?
18 3 24 ଟା ପ୍ରେସ୍ କରିବେନି ଆପଣ?
ଫାର୍ଷ୍ଟ one not
18 3 24 ପ୍ରେସ୍ କରିବେ।
Mr. Bhokta, dear Bhokta, the London Central Government Council,
CGC, my lord, CGC, my lord.
London
CGC.
Central Government Council submits that the opposite party has filed 2 counter affidavits. One is dated 18/3/2024 and the other is dated
20 August 24
20th of August 2024. Stop. The London Council for the opposite party has filed a memo in court today wherein it is stated that the counter dated 18/3/2024 may be ignored. The memo is taken on record. The counter affidavit dated 18/3/2024 stands ignored. Yes. Argue the matter, Mr. You don't want to file any rejoinder.
He wants to file a rejoinder to the second one.
Second count.
Okay, you want to file. Okay, tell us.
File, my lord.
Mr. Bhokta, Land Council further submits that he wants to file the rejoinder affidavit to the counter affidavit dated 20th of August 2024, and some time may be granted in that respect. So
2 weeks, man.
or 2 weeks time. So this matter in the week commencing from 28th July 2025.
Ma'am.
Yes.
Item 18.
The repeal manner is against the judgment of one single judgment, in which makes the certificate.
Come to that order first.
My lord.
The single bench order. Annexure 1.
1 page 28.
21/12/2023.
My lord.
Read out the order.
Relevant question.
ପଢୁନାହାନ୍ତି 2 ପେଜର ତ order ଆଉ
Review ଟା 2 page ଅଛି। Main order ଟା is fine. Advocate appears on behalf of the review applications who was.
No, just come to the
Paragraph 3.
Factual
31.
30?
Page 31.
Okay.
If there has been incorrect applications of a rule in the judgment that cannot be rectified.
1 minute.
1 minute.
Page. Which page? Page 31.
Page 31. Of the running page of the.
Acha, okay. Third para, third review petition, review order, para third.
31.
Okay.
Yes, please read it.
If there is.
Yes, you got it?
Yes, sir.
If there has been incorrect applications of a rule in the judgment
that cannot be rectified on review, there has to be adjudication on applicants' contentions regarding applications of the rule. As such, applicants' remedy may be preferring appeal against the judgment. The court is not inclined to reopen the matter. So, review was dismissed and suggested, observed that appeal can be filed.
Already
I have
come-
filed the writ
Yes,
appeal.
yes.
matter.
Let us come to the
order.
main order.
Main order. Now. So, the next page is page 32,
Yes.
relevant 34 starts with the judgment.
Yes.
You come to paragraph number 2.
Paragraph number 2 of the.
You have challenged the resident certificate.
No, the certificate was challenged by this opposite.
Okay.
Petitioner, he was the petitioner's writ.
Okay, Joshna Banti,
Banti
Sahu, you are.
Yes.
So you are in that writ petition, you are the opposite party number
5.
5. Okay. All right.
Vanulata Sahu. I
All
was
right.
appointed as Anganwadi worker filer.
Okay.
6 mailers.
Ah.
When I was appointed, he was so there are 2 applicants. His client and Jashavanti as well as mailers Vanulata. Vanulata succeeded in the interview and in the examination.
Okay, the petitioner challenged mainly on the ground that
When I was appointed, petitioner challenged the writ petition.
on the ground of that resident certificate only.
Yes.
Yes. Come to that.
Yes.
You have paragraph 2 or tapre padebe? Paragraph 2 ta
President, I'll go. I've made a list of date also.
Right. Paragraph 2
Paragraph 2. Paragraph 2. The certificate says opposite part number 5 is wife of Ghanesham Sahu of village Dinniari, post office Bhogoda, issued on applications for purpose of service. The certificate also says inquiry report dated 22nd November 2005 was produced. It satisfies applicant are recorded tenants over khata number 148 in village Dinniari, Begunia Tahsil. Opposite part number 5 on strength of the certificate obtained appointment in the Anganwadi center at Dinniari. Petitioners have challenged the certificate saying said opposite party is residents of village Nilakantapur. She was not residents of village Dinniari and could not have been so employed.
Okay. Ultimately, what is the finding?
Ultimately, finding by the Tahsildar, sub-collector and collector.
Single judge finding.
Single judge found.
You don't go slow. Don't get excited. No.
Single judge minors what happened, made an inquiry in a society proceedings here in this Honorable High Court under 226-27, adding one party TPCODL, previously SESU, who had issued me the electricity bill minors. That electricity bill was in my favor. Again, the inquiry report, first inquiry report by the SESU or TPCODL minors, after the directions of the Honorable High Court minors, also in my favor, but the learned single judge minors could not satisfied. Again, re-inquired it, saying that you go and measure in your GPS camera.
Let us read that part.
Yes.
Indeed.
Yes. That is minors, annexer.
No. The impugn order only read very.
Okay, impugn order.
May subsequent the entire order may so everything will be covered.
No, let us
It's
go
all right.
to the relevant part. If he briefs anything, you can place it because the order is in your favor. It's all right. Let him come to the operative or something he wants to place. Yes.
Minors. Paragraph 14 of the judgment, page 43 minors. My submissions will be.
So this electricity bill, etc., those are not the part of the pleading or what?
No, it is a part of the pleading.
Then what is the problem? Well, you said that he inquired into the matter, etc. As if the single judge was trial.
Honorable single judge, what happened, minors? Electricity bill was their part of the record along with 9 documents.
Yeah.
So as per the 84 rules, any document can be minors
No, so
support.
how you find fault with the learned single judge in considering the electricity bill, etc., which is a part of the record? You said that it is on the so moto he inquired into.
But in the error minors, in the social proceedings minors, only satisfy only the facts shall not be interfered minors. In a jurisdictions, there are concurrent findings of the sub-collectors, Tahsildar, collector. 3 authority has been given in favor of this appellant minors. Thus, he is the resident of Deniari as per the record, as per the documents submitted before the original authority minors. What has happened in this writ petition filed by the opposite party? So much inquiry was initiated by from the bench minors. So let us see actually where the electricity meter is minors installed. First report came from the department that it's installed in Deniari. Separate report it comes by GPS survey. It is installed in the Nilakantapur. So that inquiry is not.
Please, both of you take your seat. Let him finish it then. No, you are.
Fine. Yeah. So the second report came with it's in Nilakantapur. Relying upon that minors, the certificate, resident certificate has been minors second side. My respective submission is minors. In a writ jurisdiction in the social proceedings minors, inquiry reacquisition to evidence is not permissible as per the settled question of my last judge. I have
suppose he has filed some documents like the electricity bill to justify his claims.
Yes.
Right?
Yes.
And in the counter affidavit, you are denying that aspect about you must have state something in your counter affidavit relating to that electricity bill, or you have not said anything?
Electricity is of mine minors.
Okay. Yeah.
I have submitted electricity bill, bank passbook, I have submitted voter ID card, I have submitted ROR.
Okay.
9 documents collector has given. Based upon those documents, certificate has been issued in my paper.
Okay.
Which has been taken
in the counter affidavit. The other side must have said something about your electricity bill. The document.
No. He has said, I am not a resident of Deniari, I am resident of Nilakantapur.
No, on the electricity bill there was nothing.
Electricity bill was one of the documents relied by me along with the 9.
What was the reply given by the counter affidavit?
He has filed the writ actually, my lord. Challenging the
why are you not focusing? You are taking us here, there, and all. Let us focus. See, come to para 8 onwards of impugn order. Everything will be clear. Para 8 onwards. Come to page 37, para 8 onwards, read it.
Yes, para 8. Today, Mr. Swine and advocate appears on behalf of opposite party number 5.
That is you. You have appeared. Yes. You are
on earlier date of hearing, 31st January 23, it had been contended on behalf of opposite party number 5 that also impugned order dated 25th November 14 made by the sub-collector. The authority had referred 9 facts as appearing from supporting documents to confirm that the resident certificate was duly issued to said opposite party. In that hearing, it was noticed the rules of 2017 carried the note stipulating 2 conditions in the alternative for issuance of resident certificate. This note was not there under Rule 3 in Odisha Miscellaneous Certificate Rules 1984. As such, it cannot be said that for purpose of verifications regarding issuance of resident certificate, it had to be shown that opposite party number 5 had resided in village Deniari 1 year continuously prior to issuance of. She had to produce entry in the ROR to prove her residence. It is undisputed that husband of opposite party number 5 purchased land in village Deniari in the year 2011, long after issuance of the certificate in the year 2005. It follows that evidence relied upon particularly in also impugned order dated 25th November 14 is to be seen for purpose of adjudicating whether said order was made based on evidence. The order includes findings that at the time of issuance of certificate, no homestead land has been recorded in name of opposite party number 5 nor her husband. Second point noted is regarding village Nilakantapuru and Deniari as situated in combined Mauta. It is of no help in the adjudication. Third and fourth points observed in the said order are on identity card issued on 13th October 1996 by the college to husband of petitioner and particulars in his savings bank's account as on 18th June 1997. This information is relevant, but it must be kept in mind that information stood supplied by husband of the petitioner. there is no statement in impugned order that such information stood verified either by the college or by the bank. Observations on point number 5 is regarding electric bill issued for year 2003 to father-in-law of opposite party number 5. Observation on point number 6, 7, 8, 9 are regarding information on document issued contemporaneously and after issuance of the certificate. The 2007 rules has not appended to Rule 3. For the note, the rule requires, in absence of record, evidence of residence for period at least 1 year continuously, as must necessarily be ascertained on local inquiry. Keeping in mind the rules of 1984 didn't have the note appended thereunder on requirements of being resident for 1 year prior continuously nor record in the ROR. It cannot instead, no inquiry was necessary. It doesn't appear from inquiry report 22nd November 2005, there is local inquiry. Entry number 5 in the report mentions village Diniari, Nilakantapur. In this connection, also to be kept in mind is that on remand, the sub-collector had rejected the residence certificate on ground of improper local inquiry. The High Court, by aforesaid order dated 13th December 13 in writ petition 2666 of 2013, filed by opposite party number 1, challenging order dated of the sub-collector, though set it aside, also set aside order dated 22nd November 13, passed by the Tahsildar with the direction to hear the matter appraised and pass a rejoinder order. In the circumstances, it cannot positively be informed that the inquiry report dated 22nd November 2005 was unimpeachable. Observations on point number 5 from also impugned order dated 25th November 2014 is reproduced below. From electric bill issued by the consumer number D15A 8/2, it has seen that name of consumer is Sri Sachitananda Sahu, who is the father-in-law of Srimati Banalata Sahu. This bill has been issued to Sachitananda Sahu by electrical section Banki 2, electrical subdivision Banki of electrical division Khurda, relating to the year 2003, in which the consumer's address is written as Diniar. Earlier on inquiry from court, Mr. Mahapatra had submitted successor in interest of the supply company is Tata Power Central Odisha Distribution Limited TPCODL. On further query from court, it was ascertained that subdivisional officers at Baghamari subdivision district Khurda deals with supply to inter alia village Diniari. Accordingly, court required electricity supply company be added as opposite party number 6 to the writ petition, with directions to inform court regarding point of supply to consumer number D15A 8/2. The addition of party and the directions of it was
Come to para 14 now.
Para 14.
Para 14.
My lord. He submits power is of judicial.
This is what you are arguing now.
Yes, power is of judicial superintendent. It cannot be used to upset conclusions of facts, however erroneous they may be, unless such conclusions are so perverse or unreasonable that no court could ever have reached them. It is not an appellate power. The conclusions reached cannot be altered merely on ground of insufficient evidence. As long as it is based upon some material which are relevant for the purpose, no interference is called for. The error must be manifest and apparent on face of the proceedings, such as when it is based on clear ignorance or disregards of the provisions of law, or grave injustice or gross failure of justice have occasioned thereby. Dispute between petitioner and opposite party number 5 regarding place of residence of the latter to be basis for issuance of impugned residence certificate has engaged both of them in several litigations. Ever since petitioners lost out to opposite party number 5 in her appointment as the residence of village Diniari, thereby fulfilling the essential criterion of resident. Litigations commenced and culminated in this court prior to present writ petition by the said order dated 13 December 13 made by the first division bench in writ petition number 26336 of 13 as aforesaid, order dated 11th July 13 passed by the sub collector and order dated 22nd November 13 passed by Tahsildar were set aside and quashed. There were the directions upon the Tahsildar to hear the matter afresh and pass a rejoinder order. Parties were directed to appear before the Tahsildar. It is pursuant to directions made by the first division bench that the Tahsildar then passed order dated 6th March 14 accepting certain documents of opposite party number 5 as mentioned in the order and reproduced above. One of those documents was copy of the electricity bill issued during 2003, submitted by said opposite party. On appeal referred against said order by petitioner, the sub-collector also looked at those documents 9 in number. The evidence by those 9 documents has already been analyzed above for purpose of adjudications on judicial review under Article 227 regarding whether there is any error manifest on face of the orders or perversity or both. It has been seen that the only relevant document for establishing by way of evidence the residence of opposite party number 5 is the electricity bill. Opposite party number 5 having asserted that the resident she resides at the place where she consumes electricity or electricity is consumed at the residence of herself and family members, the bill would be best evidence. In not ascertaining the point of supply, there was omission and error apparent in the 2 impugned orders. They were made based on irrelevant evidence. Upon earlier directions, herein as aforesaid, the supply company has positively stated that the supply was made under the bill and consumer number to a location in village Nilakantapur. This assertion of fact has not been denied by opposite partner 5 in the objections filed to the affidavit of the supply company. The point of supply of electricity under the bill relied upon by opposite partner 5 was relevant evidence. This evidence was not called for by the authorities neither earlier nor in the directions on remand. The same situations had been dealt with by them earlier on the order set aside by the division bench. It appears the 2 authorities in tandem acted mechanically in returning the same findings on the same documents, where there was no local inquiry ever and inquiry report had been said to have been improper by the sub-collector. It therefore is also a case of inactions on their part. As relevant evidence was not considered, the findings amount to be perverse since also accepting the plea of judicial review being narrow in scope to sustain a findings and facts that a person resides village linearly when she or her family obtained a domestic electricity supply in village Nilakantapuru would result in a grave injustice. The impugned residence certificate and orders dated 6th March 13 and 25th November are set aside and quashed. So Annexure 5P, order passed by the collector referred by all those 9 documents, my lords. Paragraph, page number 53, lordship, may kindly come. Yes, ma'am. Collector has referred all those documents, my lord.
You are appealing from
One of the Sangha.
paragraph 6 now.
Paragraph 6. My lord, my certificate is under challenge, my lord. Issued in 2005, and my appointment is not challenged. Appointment is confirmed after direction from the division bench to remanded matter to the collector. Collector confirmed my appointment. That was not challenged. Only certificate is challenged. Yes, I am continuing.
So, what period remains now?
20 years, my lords. 20 years I have been serving, my lords.
No.
No.
Period of
How? 30, 62, another 14 years. 14 to 16 years I am yet to serve.
No, what we want to say that
Yeah.
it is a residence certificate.
Yes,
It is not based on a particular document. Like the
absolutely. 84 rule doesn't speak, my lords, any document. 84 rule I have.
That certificate has been issued considering several other aspects.
Yes.
So let us say that on this electricity aid,
Yes.
the finding of the land single.
No suggestion.
So let us say the finding of the land is that the connection has been given in a village, and that shows that you are residing. But what about the other 8 documents?
In my favor, my lords.
That is exactly.
Yes, yes.
Finding of the land and single. What were those other documents you are considering in your favor for issuance of that residence?
That's why kindly come to page 52, paragraph 5 of the order of the collector, my lord. Page 52, paragraph 5. Page 52.
We decide.
Yeah, the only is to be decided is whether OP number 4, Banalata Sahoo, belongs to village Nilakantapur or village Dinyari, or any village which comes under the jurisdiction of Dinyari Anganwadi center area. It is undisputed that the petitioner belongs to village Dinyari. Had the petitioners who stated that she is a permanent resident of village Dinyari. She has also filed Xerox copy of residential certificate issued by the additional Tahsildar, Begunia, filed as annexure 2 to the writ petition in the Honorable High Court.
Here, that is not dispute. You are also not disputing that he belongs to village.
Is my case. See, he has filed the writ petition that time. I have not filed.
That the petitioner belongs to village Dinyari.
He was the writ petitioner. She was the writ petitioner.
So that is not dispute. Dispute is that you, the Banalata Sahoo, whether he belongs to
OP number 4, man, Banalata Sahoo.
number 4, you are appearing.
Yes, man. The Banalata Sahoo, Begunia filed annexure 2 to the writ petition in the Honorable High Court, which may attention was drawn. My attention was drawn during hearing.
This is the petitioner belong to village Dinyari. Now you should consider whether you belong to village Dinyari.
Yes, ma'am. Next, she has also my client, madam. She has also invited my attention to matriculation certificate and mark sheet filed as annexure 3 and 4, respectively, in her writ applications in Honorable High Court as token of proof that she belongs to village Dinyari, that she is a resident of village, being undisputed, there is no necessity to go for any evidence. I also recorded the statement of OP number 4, Srimati Banalata Sahoo. Srimati Sahoo, in her deposition, stated that her home is at Mauja Dinyari, where she is working as an Anganwadi worker. She has admitted that though her father-in-law belongs to village Nilakantapuru, she and her husband are the residents of village Dinyari. She exhibited the voter list supplement of 2006, corrected up to 2006, and published on 10/3/2006, wherein at serial number 1140, the name of her husband Ghanesham Sahoo and serial number 11401, her name appears against house number 150. The petitioners filed a certified copy of the old voter list wherein the name of the opposite party for and place in village Nilakantapur at serial number 467 in house number 20. However, in the new voter list corrected up to 2006, in the supplemental list, the name of the OP number 4 and her husband finds place in addition list. The opposite party number 4 also produced a copy of the transfer certificate CLC of Begunia College in Exhibit 5, wherein the permanent address of our husband Ghanesham Sahu is shown as village Dinyari. This certificate has been issued by serial number 330628-2006. I also perused the certificate of Sarpancha Padodio GP, in which the Sarpancha had certified that OP number 4, that is my client panel, is known to him and she is a permanent resident of village Dinyari, Exhibit 4. The OP number 4 has also filed a copy of residential certificate from the additional Tahsildar Begunia, wherein the additional Tahsildar miscellaneous case number 2106-2005 has issued the resident certificate that Srimati Banalata Sahu, wife of Ghanesham Sahu, is a native of district Khurda and her family ordinarily reside in village Dinyari. This certificate was issued on 22nd 11/2005 by the additional Tahsildar. The learned advocate appearing on behalf of the petitioners could not refute the documents filed by the opposite party number 4 regarding proof of her residence at village Dinyari. The learned advocate also refused the cross-examinations, but requested for further inquiry by the Tahsildar Begunia with regard to residential certificate issued by him in favor of Banalata Sahu. In view of the documentary evidence, I am not inclined to accept the contentions of the learned advocate for the petitioners that Banalata Sahu is not a resident of village Dinyari. The residential certificate issued by the additional Tahsildar in 2005 Investigations case 2196 holds good till it is not set aside by a competent appellate court, as the said certificate has been issued in due process of law in quasi-judicial proceedings by the additional Tahsildar in exercise of his statutory powers. The learned advocate for the petitioner is also silent about the CLC issued by the principal Begunia College, right, serial number show Exhibit 5, not the certificate issued by the GP as such. I am not inclined to interfere with the selections made for the post of Anganwadi worker. Tahsildar order against sub-collector. Collector's order, again it will come to be.
এটা অঙ্গনবাড়ি অপিল order.
এটা অঙ্গনবাড়ি অপিল
আছে অঙ্গনবাড়ি
was challenged by the yeah, maybe one. But electricity bill is not the only criteria or the as such. But 84 rule is very clear, my God. I fall under the 84 rule. Here my honorable single judge relied upon the 2017 rule, my God, which is also error, my God, apparent on the post. 84 rule re hoche mo se review re mo annexer kartili review ta achi alta copy ni ko eta ki edu pori dechen ha achhe yes yes page 30 page 28 starts R/2, my lord. Either page in institution of the clause 5, my lord, rule 5, so kindly have look page 30. Institutions of the case and inquiry. The revenue officer shall initiate a case record, scrutinize the document furnished by the applicant, verify the relevant records, if any, in the office, and wherever necessary may himself inquire into the matter or call for a report of inquiry by a specified date from an officer subordinate in the rank. This is the requirement. Then the order on the application, rule 6 minus. If on the basis of the documents, records, and the result of the inquiry, if any, the revenue officer is of the view that the certificate applied for may be granted, he shall pass necessary orders in the case record and sign the appropriate certificate specifying the purpose solely for which it has been granted. The certificate shall be handed over to the applicant or his duly authorized agent on due acknowledgement of the receipt.
Revenue officer has been defined under 2T.
Yeah, that's additional Tahsildar, Tahsildar, all.
Then against that, what are the provision appeal is there?
Appeal is there, sub-collector can file appeal, clause, rule 8 manner.
Accordingly, this certificate was issued in your favor. Appeal was challenged, filed by them.
Then that was confirmed.
That was confirmed.
Yes. Then they have traveled to High Court. In High Court, let's say, already seen the finding of my unable single judge.
So, it says that there is nothing that if you want to issue a resident certificate, what are the documents you are required to see?
Yes.
If there is nothing in that.
That not specified.
Specified.
Yes.
But
in practice, all these documents are considered: bank passbook, my passport, or voter ID card, electricity bill, and ROR. Manner.
The single judge.
Yes.
By passing the input order.
Yes.
Have only taken into account.
Yes.
About the
Electricity bill, absolutely, man. That,
the other aspect.
which is wrong. Other aspect not whispered manner. Other aspect and other factual aspects which has been taken on account by the Tahsildar, all the collector, or the sub-collector, not managers analyzed.
Council for the state, is it correct?
That other document are there.
Because she has also placed the order, we find that whatever the observations of the land and single judge is on that electricity bill.
Yes, my lord.
But electricity bill is not the sole ground. On
Maybe
the
one of
basis
them.
of which it is one of the
Electricity
ground.
bill is in the name of father-in-law of the petitioner.
Right.
But
So-
the case of the petitioner is that she and her husband residing in village Dimiria.
That is the permanent resident. of-
Yes.
Voter ID card and
Voter
everything.
ID card, so many things, and there is no
Deliberation.
deliberation in the
That
single
is-
judge.
Others.
Yeah, what do you say, Mr. Counsel? Is it no, the factual aspect which you are, is it correct or not? The other aspect which you are taken into account. आगे कुहतु 1984 रूल applicable ना से जो 84 applicable 84 rule तो अपन पढ़िले से भी place कले 84 rule रे is there anything that these are the particular documents which are to be taken into account by the revenue please listen to us are to be taken into account by the revenue officer while issuing the resident certificate. There is nothing, so it is simply said that you are to inquire into the matter.
Yes. Only
Inquiry has been made. Several documents have been taken into account.
There is subsequent developments, ma'am. On Mr. One, my lord, the resident certificate has been issued.
What is subsequent development?
As because there are various reapplication, thereafter she married and voter list was corrected. These are subsequent documents, my lord. The first only document she has produced, the RO of the father-in-law.
These documents, which when the order he has placed now, the collector's order, in which has confirmed the order passed by the revenue officer, that is additional Tahsildar, and that additional Tahsildar has issued the certificate in the year 2005, and when this new rule came into force, 2017. So obviously 1984 rules governs the field, and at that point of time, if the inquiry has been conducted, several documents like voter ID card.
These are what produced at all. These documents have not been produced at the time in 2005.
Document is not necessary, my lord. It is
Inquiry. It is
the inquiry.
Inquiry is envisaged in the rule. While inquiry, it is the discretion of the Tahsildar to look into any document. As simple as that.
If
He has seen all voter ID card and everything.
If somebody has no landed property, but he is residing in that area, the inquiry will show that whether he is residing in that area for a period of 1 year or
1 year.
Suppose if you are right, it would have been, suppose the prescribed procedure would have been followed. The residence certificate हमें तमु A, B, C document file करियाउ पड़िबो. जदि गोटे देखै नथिबो से document नथिबो ताले matter and certificate, in spite of that certificate has been issued, matter is different. But it is simply stated that an inquiry is to be conducted. In what manner?
Not but the inquiry based on a document. Then what is document I will come to your lordship. Unless your lordship come to the read application.
No, read रे नु आपण rule देखांतु. Rule रे कोठी कहूची जे को document basis रे inquiry करियो. Is there anything? So if it is not there and the authority has taken into account so many documents, voter ID card, this school living certificate, other things. So bank document,
as well as local inquiry.
as well as
Local inquiry. And moreover, he has been working since last 20 years.
Otherwise, working, he will work, that is not a matter. But
You not challenge that point.
fourth read application, my lord.
the fourth or fifth we are concerned with the present one.
Yes, ma'am.
When the finding has been arrived at by considering several documents by the two authorities,
Yes, ma'am.
let us say the additional Tahsildar and the sub-collector.
Now, prior to that, in unnecessary 11 of the repeats, the same person.
Collector has confirmed it.
No,
So on the basis of one of the document, how the finding was set aside?
The Tahsildar also rejected the residence certificate in unnecessary.
No. We are concerned with the latest one. The order is the order confirms the issuance of certificate on dated 22/11/2005.
Yes.
You don't go to the history.
Yes, ma'am.
The miscase number is given and the order is dated 22/11/2005 and that order was confirmed by the collector Khurda, which was challenged in the writ petition.
Yes, ma'am.
And the single judge has considered only one document out of the several documents which were filed, which were considered by the authorities in either issuing the residence certificate or confirming that yes, the issuance of residence certificate is proper and justified.
Next, sir, your lordship come to page 9 of the order. The single judge has considered all the documents. It is undisputed the husband occupying of purchased land in village Dineri.
Or any other submission,
Ma'am.
we find no in that it cannot be sustained. This writ appeal has been filed. This writ appeal has been filed by the petitioner, appellant, Vanulata Sahoo, challenging the order, the judgment dated 24/4/2023, passed by the single judge of this court in WPC number 716 of 2015. So also the order dated 21/12/2023, passed in by the same judge in review petition number 187 of 2023. The where is you the writ petition order ta kahin? The writ petition copy ta? The writ petition copy ta hato. Okay, it's all right.
With the Paratri order, impine order.
Writ petition file ta eta. That must have come, but actual scenario must have. The writ petition was filed by Josovanti Sahoo, the respondent, challenging the order dated 25/11/2014 passed by the sub-collector Khurda Annexure 13. In holding that Banolata Sahoo, the appellant is a resident of village Tiniari. The writ petition also challenged the order passed by this one order you are challenging, that is Annexure 14.
13, 14. Annexure 13 and 14.
Acha, Annexure 13. Annexure 13 ta lag diyantu. That is the order passed by the Tahsildar Begunia in holding so and so, and the order dated 25/11/2014 passed by the sub-collector Khurda, right?
Yes.
But that page is missing.
70.
Those orders are also here in the writ appeal.
170.
Show the
Yes,
it's not
Kindly have a look to page. And then page 73 here, my order.
Right. In dismissing the appeal file by, this is the order challenge.
The same in appeal. The Tahsildar's order has been challenged in appeal before sub-collector. Let's come to 76, page 76. Page 76. And the guy's first paragraph.
Order dated 6/12/2013 wala. Another order is dated 25/11/2014 passed by the sub-collector Khurda, right? There is no appeal number, it is not there. Simple appeal. Appeal number is not there. In dismissing the appeal filed by the respondent, and allowing the appeal preferred by the appellant, and holding that the Tahsildar Begunia has rightfully issued the residential certificate in favor of the appellant, Banolata South. from the से जो appellate court रो जो order टा पढ़ुଥିଲେ सेटा कोठी देखुचंती
Collector order, man.
collector order
Minor. Page 74, starts from lead to appeal minor. Sir. I beg to apologize. Page 50 minor. Page starts from this. Annexure 5.
Page 52.
From the order dated, this is 29/2006 or 28/9? You would have placed for it. 28 no to?
Okay.
From the order dated 28/9/2006, passed by the Collector Khurda, while in terms of the order number 3 dated 22/8/2006 of this court in WPC number 5321 of 2006, it seems that it was held that the residential certificate issued by the additional Tahsildar on 22/11/2005 in miscase number 2196 of 2005 holds good. And the collector has observed in paragraph number 6 as follows, for the paragraph number 6. From the impugned orders which were challenged before the learned single judge in WPC number so and so, it appears that several documents like one document that is from ROR,
College living certificate.
college living certificate, voter list,
electricity bill,
Bank passbook.
from a bank passbook were taken into account while issuing the residential certificate in favor of the appellant Vanalata Sahu by the additional Tahsildar on 22/11/2005, which was confirmed by the Collector Khurda. But from the impugned order of the learned single judge, we find, what is that order dated? Writ appeal
24/4/2023.
Impugned order dated for them to 24/4/2023.
Annexure 2.
We find that
Only
the entire deliberation has been made with respect to the electricity bill, and accordingly the residential certificate issued in favor of the appellant and the order dated 6/4/2014 and 25 November were set aside. The learning counsel for the appellant strenuously argued that when such a certificate has been issued, taking into several documents into consideration, and the learned single judge has not whispered anything regarding the other documents, basing on only the electricity bill, the residential certificate issued in favor of the appellant should not have been set aside. The learned counsel for the state as well as the learned counsel for the respondent fairly submits that the impugned order has been passed solely basing on the electricity bill. We are of the view that when the residence certificate, stop, 1984 rules, stop, read petition or review petition? Acha. Okay, Orissa miscellaneous certificate rules 1984 prescribes
Rule 5.
regarding the issuance of miscellaneous certificate, and one of such certificates as per Rule 3 is the resident oblique nativity certificate. And Rule 5 of 1984 rule states that the revenue officer shall initiate a case record, scrutinize the document furnished by the applicant, verify the relevant records, if any, in the office, and whenever necessary may himself inquire into the matter and call for a report of inquiry by a specified date from an officer subordinate in rank. And Rule 6 states about the orders to be passed on such application, and it states that if on the basis of the documents, records, and the result of the inquiry, the revenue officer is of the view that the certificate applied is to be granted, he shall pass necessary orders in the case record and sign the appropriate certificate, specifying the purpose solely for which it has been granted. And the certificate is to be handed over to the applicant or his duly authorized agent on due acknowledgement of receipt. Revenue officer has been defined under Rule 2B of 1984 rules. Stop. It is very much clear that except indicating that an inquiry is to be conducted and documents are to be scrutinized, there is nothing in the rules that what are those specific documents to be verified by the revenue officer while making the inquiry. In the case in hand, it appears that several documents apart from the electricity bill was verified by the revenue officer while issuing the resident certificate in favor of Panorata Sahoo. And that order was confirmed in appeal by the collector. Therefore, the learned single judge, even if found fault in the electricity bill, should not have set aside the resident certificate issued in favor of the appellant without discussing or without deliberating on the other documents which were relied upon by the additional Tahsildar, so also considered by the collector. Therefore, we are of the view that the impugned order passed by the learned single judge is not sustainable in the eye of law. Accordingly, the same is hereby set aside. A writ appeal is allowed. Yes.
Your lordship hold this bench to after lunch, after there is a yesterday's assignment that states on Monday, Wednesday and Friday, your lordship will continue till the last hour. And only dedicated bench, criminal bench, that your lordship nowadays listed after lunch. That is on Tuesday and Thursday.
What problem you have?
We were in doubt. This list is on those terms. Would your lordship take up
No,
these
only
matters?
except Tuesday and Thursday, this bench will continue.
These matters which are left over, it is to be just another list is to be published on Wednesday, and all these matters will be listed on that. This is not for 3 days. It is for 2 days list. It is only this list which we are taking up just now. It is only for today. But as for our what we adopted, whatever matters are left out, it is to be taken off again on that 2nd of July 2025. Because tomorrow there will be another bench.
Yes, tomorrow and Thursday, that dedicated bench.
Right.
Yes,
That's it.
so that way clear.
Your lordship, your name of opposite fact number 6 may be I beg your pardon, your lordship. Beg your pardon, your lordship. If your lordship,
On 18th pillar.
Yes, just a minute. Prakash Behra, Nandakishore Sethi, okay, and Mr. Dilip Kumar Das. ଆପଣ ମାନେ ବସନ୍ତୁ ଶୁଣାଣି ଚାଲୁ. Yes, sir.
On 18th file
on
commencing the
18th.
hearing, Millard, Lordship directed us to submit a report regarding the past conduct project.
18/6/24.
Yes, the report is rating him submitting the report.
That, yes.
Person file affidavit.
1 minute, let us see that. That report first.
What about their affidavit? Give it to the operator. Have you supplied the copy of the affidavit?
Yes.
And have you supplied the reports to this one? Please supply. No, you have given a huge bunch. Why are you giving only this much? Please give the entire list.
Yes.
You have given the conduct, post-conviction conduct, then the medical reports also you have given. So, and some statements also you have recorded. Have you furnished the entire thing?
Yes.
Statements ଅଛି ଆପଣଙ୍କର? ହଁ କାହିଁକି ମୁଁ କହୁଛି ଏଇଟା ଏତେ ମୋଟା ଜଣା ପଡୁଛି ଆପଣ ଗୋଟେ ପତଳା ହଉଛି ତ ବୋଥ ସାଇଡ ହେଇଯାଇଛି ବୋଲି ଜଣା ପଡୁଛି ସେମିତି. ହଁ ठीक है। So this will be considered after we finish the matter on merits. We will consider. We are just mentioning that you have submitted. Let me do. In pursuance of the order dated 18/6/2025, the Land Council for the state has furnished a detailed information about the condemned prisoners Prakash Behera and Nandakishore Sethi. Which includes their psychological condition, post-conviction period, and conduct after conviction. It's also about the health condition report. Copy of the report has been furnished the Land Council for the condemned prisoners, and the report is taken on record. Stop. Mr. S.R. Mulia, Land Council, appearing for the appellants in CRLN number 1166 of 2024, has also filed the affidavits of the appellants, separate affidavits of the appellants, in pursuance of the aforesaid order dated 18/6/2024, serving copy on the Land Council for the state. Stop. The affidavits are taken on record. Yes, you proceed.
The last occasion, out of the circumstances, already we have discussed that DNA test report.
Just a minute. Last scene we have discussed, then motive discussed, then DNA test report discussed.
Now it is the turn of leading to discovery.
Now,
I see my lord. The order dated 9/14/12,
there are three seizure lists. No, there are, I think there are a number of seizure lists, but the relevant seizure list which are relevant, I think it is one is that Exhibit 1. It is the seizure of wearing apparels of appellant number 2, that is a black color full pant, and then Exhibit 4 is the seizure list of Hero Honda. What is that? Honda motorcycle, Honda motorcycle and Hapsat. That is in Exhibit 4. Then another seizure list is Exhibit 19, which relates to the seizure of a gamusha and kotari at the instance of appellant number 1, Prakash alias Babuli Behra, and then the last seizure list is Exhibit 21, which is the wearing apparels of Prakash Behra, that is a full shirt and jean pant. These are the seizure list, 4 seizure list. Yes. No? Okay. So let us go one by one, since we have, we are told, both of you told that so far as Exhibit 1 is concerned, the relevant witnesses are PWs 1, 2 and IO 41, right? Yes. So that is about the wearing apparels of the appellant number 2. And this particular full pant, from this full pant, what is the DNA test report? Anything found from this full pant which is marked as MO23? Because if it is nothing was found, then it is a simply seizure of wearing apparel, full pant. If something was found, then it's all right.
Yes, sir.
Page 359.
Page 359, madam.
Yes, sir.
359. Paragraph 7.
Exhibit
359.
Volume 2 though?
Again, volume
2, ma'am. So this has got link to DNA report. And the relevant page is page number 359. अच्छा ये जो particular पैंट रू अपरेंट नंबर 2 रो पैंट रू कौन बाहर ला?
I am reading below.
कितना नंबर सीरियल?
Serial number 7.
DNA profile exhibits of accused Donjo is a human male origin and matching with DNA profile of exhibit B, caught piece of banyan, so on. So it matches it, sir. Later. Okay.
It's with the Biranj.
Biranj, right. So let us know that what is the evidence. What do you want to say about this seizure?
People want to know for probability. People want
just a minute. Let us mention.
PW1.
1 and 2.
Just a minute. Seizure list. Exhibit 1. It is a seizure of black color, na? Black color full pant, which has been marked as MO 23. Of appellant number 2, and the relevant witnesses are PWs 1, 2 and 41, right? So, and it is linked to DNA report which is available in volume 2, page number 359. So you mean to say, Mr. Mulia, that PWs 1 and 2, they don't support the seizure of this pant. Declared hostile. Do not support the seizure of full pant of A2. Now, so the only witness remains is PW 41, right? Let us come to that. PW 41 say portion ko padhe usko.
1 and 2 from hostile.
That I have noted down. We have noted that. You come to that PW 41 of relevant page kete. A particular aspect of the duty provides. If black color full pant of 30 black color full pant of appellant number 2. Para 23 minor, page 199. 199. Volume 1. Volume 1. Volume 1. 23. Para 23. Page kete 199. Para 23. 23. Okay. Hold on. After making the seizure of recovered article, I kept in my personal custody with proper packing and seal. I examined the seizure witness, Schedule 15 and Suramani Pradhan. Then after Hudson of the accused Ranja and being led by him, I proceeded to the third place of recovery, which is situated on the roadside. Ranja is that appellant number 2. Yes. Yes. I proceeded to the third place of recovery, which is situated on the roadside of Pathargumpa Road near Pathargumpa. In the presence of witnesses Schedule 1 and 2, accused Ranja gave recovery of one black color full pant, 10 with block, on which a sticker written thereon as only on the back side of the pant and above back pocket. Then I prepared seizure list at 12:15 AM, had exhibit 1/2, and my signature thereon is exhibit 1/3, and exhibit 1/4 is the signature of the accused under the said black color pant of the accused is marked as MO 23, and the paper she affixed on the packets marked as exhibit 54, and my signature thereon marked as 54/1. The signature of the accused marked as 54/2 and 54/3, 54 are the signature Schedule 1 and 2. ठीक pause दियो सेती तो अच्छा ये जोटा এটা কোড মিଳିଲା ये ଜିନିଷ ଥାର୍ଡ ପ୍ଲେସ୍ କଣ ଠାକୁର ଗୁଡା କଣ ବାହାରେ ପଡିଥିଲା ନା କଣ ରୋଡ ସାଇଡ କହୁଛି ରୋଡ ସାଇଡ ଅଫ ଠାକୁରଗଡ ପଥର ଗୁମ୍ଫା ରୋଡ ନିୟର ପଥର ଗୁମ୍ଫା ଆଚ୍ଛା ଏକ୍ସିବିଟ 1 ଟା ଦେଖିଦେଲେ ଜଣା ପଡିବ ଏକ୍ସିବିଟ 1 ଟା କୋଉ ପେପର ବୁକ୍ ରେ ଅଛି 264 exhibit 1 is page number 264 of volume 2. Place of seizure से लिखा है from a bush on the roadside of Thakurgad Swanso near Swanso. प्रशांत प्रधान এটা হলো পিডব্লিউ कहते हैं উইটনেস जो আছেন উইটনেস দিয়াই পিডব্লিউ कहते हैं प्रशांत कुमार प्रधान পিডব্লিউ 1 ଆଉ ଜିତେନ୍ଦ୍ର ପିଡବ୍ଲ୍ୟୁ 2 ଗୋଟିଏ କଳା ରଙ୍ଗର ଫୁଲ ପ୍ୟାଣ୍ଟ ଯାହାର ପଛ ପ୍ୟାକେଟ ରେ ଓନ୍ଲି ଲେଖା ଥାଏ ଷ୍ଟିକର ଲାଗିଥାଏ ରକ୍ତ ଆସୁଛି ଏମଓ ଆସିଲା ବାହାର କରନ୍ତୁ ଦେଖିବ उल्टा कोई दिले ये बाहर करूँ कला रंगर फुल पैंट अच्छा ये जो गोटे बुदा भितर बाहर करके देला बेली लिखा है आपनकर सीजर लिस्ट रे 264 रे एमती तो किसी एविडेंस आसुनी से खाली कहउची जे रोड साइड को नहीं कि जेमती एज इफ इट इज एक्सेसिबल टू ऑल 27 has some relevance if the place is accessible to all. If it is not a secret place and it is seized at a place which is accessible to all, then what would be the effect of such seizure has been described or stated in number of decisions. Because that would be known to everyone. So it cannot be said that the accused has exclusive knowledge that this is hidden there, and so he brought it out, and that is how the facts discovered in pursuance of such statement. If it is lying in an open place accessible to all, then it cannot be said that it has been discovered. That is the basic difference in section 27. Number 23. खुला तो खुला पैंट पूरा खोलो गोटे कला रंगर फुल पैंट जार पछ पैकेट ऊपर ओनली लेखार स्टिकर लगे पछपटे कोडे अच्छा ओके रक्त कोड लगे देखे सामने अच्छी ସେଇଠୁ ନେଇଛନ୍ତି ସେମାନେ ଏଇ ଯୋଉଟା ପୋର୍ସନ୍ସ ଗୁଡାକ ସେଇଥିରୁ ନେଇଛନ୍ତି ହେଲା ଓକେ keep it but okay Mr. Mulia, what is the cross examination on this evidence which is adduced by so merely because let us say independent witnesses have turned hostile. But if the evidence of 41 is believable, so why we disbelieve that at your instance, this particular pant has been recovered, which contained the blood stain, which matches with the blood of one of the deceased.
Sending up, sending exist to the BFSL matter, SFSL matter. Kindly see matter.
Page देखो दिले बड़ा पढ़ी ले
order sheet minor. Order sheet of SCG minor.
No, before going to that, we just want to see that on this particular point, have you cross-examined the this PW 41?
That point.
Or have you challenged this seizure, or it has remained unchallenged?
Even unchallenged.
No question put.
But you have put the question PW about PW1 and PW2, 34. Cross examination para 34. It is not a fact that the case I have recorded. Pause 116. I 205. 205. Cross examination.
205.
34.
That is the only suggestion. False statement वाला. बाकी यहाँ पर question तो नहीं होगा.
Nothing.
Okay. So just a minute.
Only suggestion to
seizure of pant not challenged will be cross-examination of IO PW 41. Whether any question has been put in the accused statement, which is that question? To each of the appellant. And what is the reply? Each of the appellant document actually. It is necessary to be appellant number 2 only. So appellant number 2 raw accused statement
57.
57. 57 raw 41 ऊपर question कोड आरंभ होईची 41 question Arambechi 148. Right, page number running page 79.
79.
हाँ जे सेई क्वेश्चन टा से जो कला पैंट ऊपर क्वेश्चन टा कोटा
MO 23. Exhibit 1.
Question number 207.
207.
Right, 206, 207.
Just
Page 88.
Under point 194 also, my lord.
194.
My lord. Page 86.
It further transfer from the evidence of on the way to your house, you had kept hiding full pant, stained blue shirt with tight inside. What have you got to say? It was just statement this 27 statement.
206.
Huh?
Question number 206. Page 88.
What is the problem?
He further transfer from the evidence of Table 41 that in presence of witnesses, you gave recovery of one black color full pant stained with blood on which a sticker written thereon as only on the back side of the pant, which is above the back pocket. And the same was seen by exhibit 1/3 and exhibit 1/4 is a signature here. What have you got to say? Nahi.
After next question. No, no, it no.
MO 23.
MO 23 pura.
Same one.
Further transfer from the evidence
हाँ,
of Table
yes,
41
same. वही हो गया
that
तो
a black color pant of the accused was produced before the court and marked as MO 23 with one paper sleeve affixed on the pocket marked as exhibit 54.
So these are the two questions relevant. Pachrai.
The same question was put to the other accused also.
Other
not
accused,
necessary.
not
But
necessary.
still you put that question.
Acha. That is accused statement of appellant number 2, page number 88, questions number 206 and 207. So that date of seizure, as you just pointed out, it is dated when that seizure was made.
12/10/17.
Acha. Date of seizure is 12/10/2017 as per exhibit 1/2. Okay, when this particular pant along with other supports were forwarded to the for chemical examination.
14/12.
What is that forwarding report is dated which page?
Exhibit
57. This 57.
Page 343.
349.
Starting from 343.
Acha, forwarding of PAN for CE. କେବେ କହୁଛନ୍ତି?
14/12/17.
14/12/2017 exhibit ହଉଛି 57.
And it is at serial number
Serial number କେତେ କଣ?
29
Serial number 29.
at page
345.
Serial number 29, page number 345.
Along sold my not in civil condition.
One bloodstained black color full pant of accused Rangios warrants on which only sticker has been mentioned. Seized from the booth at so and so. 12-10 production by so and so. It is marked as exhibit Q. ସେଇଥିରୁ ରିପୋର୍ଟ ଆସିଗଲା ଇଏରେ. So just a minute, we are noting down your submission 1. Nothing mentioned in forwarding report that it was in sealed condition. This is number 1. Number 2, though the seizure list indicates that pant was seized from inside the bush, but IO PW 41's evidence is silent. Acha, is there anything where he kept this pant?
The evidence of Rule 41, madam.
Page 199, paragraph 23.
199. Paragraph 23.
And also last two lines in paragraph 27.
No, okay, go to. Just a minute. We are noting down, so. Roman 3, IOPW 41, para 23, page 199. How full line would have important?
After making the seizure of recovered article, I kept in my personal custody with proper packing and seal.
Proper packing and seal. Okay.
Thereafter, at page 202, Miller.
202.
Paragraph 27 towards the last two lines.
Just a minute. Para 27, page 202. Two line tapondu.
Last paragraph 27, the last two lines. After examination of weapon of offense, MO6. That's the difference.
No. We are not on weapon of offense.
Para 23, last line.
Para?
Para 23, page 200. Last, I came back to the PS along with the accused person and seized the article and then kept in my page 200, page 200, last to fourth line, last to fourth line.
Examine PW 4 and 10.
I came back to PS along with the accused person and seized article, then kept it in my custody. Acha. So also page 200, I came back, ... in my custody. Okay. So, Mr. Mulia, we just want to ask you, this is the statement which he has made in the chief examination, that he has kept all these articles, including this pant also, in his personal custody, but under proper packing and seal. Any cross-examination on that line? No.
It's a para 29, madam. 200, page 203.
203.
Para 29, fourth line.
On 25.
On 25/11/2007, I handed over the charge to my successor, Patiya Maji, along with all the relevant documents and mal items. During the course of my service tenure, I know Patiya Maji and acquainted with her signature and handwriting. During the tenure of her investigation, on 14/12/2017, she had forwarded the mal item to FSL to the order of STG Matamali, and the report was issued directly by the court.
Just a minute. So, directly by the court, relevant. So ये निज कस्टडी रखिले अंडर प्रॉपर सील ताकू हैंड ओवर कले प्रतिभा माजी हैज नॉट बीन एग्जामिन्ड एंड प्रतिभा माजी कोर्ट रखिला से एविडेंस नहीं एवं ताकू आनी प्रोड्यूस कले ये कोर्ट रे प्रोड्यूस होईची एसडीजीएम आत्मली
हैंडेड ओवर कले भी फील कंडीशन से यूज नहीं and it's fine. Exhibit 57 minus this report the following report
ये जो ये टा
following report तो कौन है seal condition the court seal करी पठा रहा seal मार्क भी नहीं स्पेशल भी पठा रहा
3 page 3
the 343
343 yes 343 का कौन है
forwarding
report
हाँ
कितने नहीं seal करी पठा रहा seal condition seal वाला कोर्ट
नहीं आधेरे ये जो description of exhibits अच्छी जोटा जो कंडीशन रे प्रोड्यूस हेइथला मजिस्ट्रेट को पायर सेटा लिखा है तेणु ता देहरु लेट अस से आइटम नंबर 1 दैट वाज प्रोड्यूस्ड इन सील्ड सो 1 2 हमें से दिन देखौतलु तो केते गुडा को जिंस सील्ड रे लिखा है
एते गुडा ना
आ केते गुडा को नाही हां हमर ए जो येटा पे हमें जो विषय डिस्कशन करछु दैट इज 29 सेटा रे नाही सील्ड विषय रे
order magistrate offense is very important matter. Order से magistrate. Page 448 man.
448.
Order dated 14/12/2017.
Yes.
Is
14/12/17.
8 SDGM order sheet. डेटेड कितने 14/12/2017
ऑर्डर नंबर 9
अच्छा कौन लिखा है
It was issued by my lord IAS Patiya Maji madam. Proceed kindly. Last corner रहेगा. Patiya Maji. Receive को लेंगे article. Exhibit 59 shows my lord. It was received from one.
No. Exhibits गुड़ा को रिसीव कले क्या कुछ दिया गया है जो वाला ना तमें गुड़ा को पठाई दियो डायरेक्टर एसएफएसएल को तो से एग्जिबिट्स गुड़ा को रिसीव कले इटे लिखा है जी रिसीव कले दैट इज
सील कवर
आईएससी
लिखा है सील
एंड एग्जिबिट
आईएससी तो
ओ एथि मध्य लिखा है नहीं जो सील कवर
रिसीव कले आईएससी
हाँ रिसीव
आईएससी Patiya Maji रिसीव कले
हाँ इटा लिखा है जी बरा ताकि ये प्रोड्यूस कला परे कोर्ट देखिले इटा होची कनेक्शन रे प्रेयर हिची टू सेंड इट टू द डायरेक्टर एसएफएसएल रसूलगढ़ फॉर सी एग्जामिनेशन प्रेयर टा को अलाउड कले एग्जिबिट्स टा को वेरीफाई कले आउ फॉरवर्डिंग रिपोर्ट आउ सीजर लिस्ट को वेरीफाई कले तापरे सेंट एग्जिबिट्स टू द डायरेक्टर एसएफएल तापरे दे देला आईआईसी को आईआईसी सेटा नहीं कि प्रोड्यूस करथि वो बाद का जरिया रे प्रोड्यूस करथि
एग्जिट 59 में देखो एग्जिट 59 पेज 349
एग्जिट
349 पेज 349 एग्जिट 59
यस
yes
कौन refer memo number so and so, advise dispatch of one seal packet through Summit for 344, see RR bag, CC number and it is a special police station. No, it's not necessary that IIC should produce it. IIC has entrusted. RR bag was examined as a period 26 mile, not whispered as anything. Oh, yaku examine is mile, period 26 mile. Trust me, RR bag. Just 26 mile.
RR bag.
Yes. 26, I think. Page 147. Rasmi Ranjan Bag, Constable number 344. Oh, ठीक है तो. Not whispered anything about that. But I'm a permanent placement. ओ सीए कहिनी जे मते मैडम कोन प्रभातीना प्रतिभा कोन हां प्रतिभा मैडम मते देले कहले नेकिनी जाइकिनी डायरेक्टर स्टेट फोरेंसिक साइंस लेबोरेटरी आकु नै जा एवं से तांकरी निर्देश मानी मु नेकिनी तांको प्रोड्यूस कली एई एविडेंस ये देइनी पीडब्ल्यू 20 या तो कमांड पूरी
शील्ड कवर
But fact remains that it was produced and it was examined. Question is that somebody has produced it and his name is there in the report, but of course that witness has not stated in that way. Another thing, madam, you seal bucket through this is dispatch, Harman dispatch one seal bucket. For the order sheet, the master disclosed, madam, the packet was sealed. You know, seal packet disciple.
That's MSC page 351, serial number 29.
Just 351. 51.
Serial number 29 in respect to that full packs.
No, that is there.
Yes.
It's a sealed packet.
Sealed packet.
See, just a minute. Page number 351, serial number. What number serial?
29.
29 indicates.
Actually, madam, from serial number 25 to 30 are relevant.
That it was produced in sealed condition. No, Mr. Tripathi, what he exactly pointed out that if the forwarding report indicates that which are the items which were produced in sealed conditions and which are the items in which there is nothing mentioned that it was produced in sealed conditions. And one of such item is this pant.
Yes.
In forwarding report, it is mentioned that there was no seal in it, right? And the magistrate order also does not indicate that he put seal in the items which were produced before him in unsealed condition. There is nothing in that. All the articles were handed over to the that lady Pratibha, and one constable was sent to the forensic science laboratory to give those exhibits for chemical examination. Of course, that constable has not stated anything, but when we find that in the report of the C report, it is mentioned that all these articles were in a packet. गोटे पैकेट भितर ये सबू तक सील्ड होइकिन पसथिला ता देरे पैंट भी थिला अन्य भी आइटम थिला दैट इज गोटे बॉक्स टाइप रो सेइथरे एगुडा सब पसथिला बॉक्स टा भी सील्ड पैकेट इट्स नॉट दैट इंडिविजुअली से लैंग्वेज देखिबे जे वन सील्ड पैकेट भितर एगुडा सब ए सील्ड पैकेट गुडा सब थिला राइट तो प्रश्न होउची जे ताकू सील पुनी कोठी करा गला जदी सेटा आमे पैंट कथाटा कहू पैंटा जदी अनसील्ड कंडीशन रे आपन को फॉरवर्डिंग रिपोर्ट हिसाब रे प्रोड्यूस हला एवं सेही भली अवस्था रे हैंडओवर कर दिया जाइछि आईआईसी को किंतु प्रोड्यूस होइछि भुवनेश्वर फोरेंसिक साइंस लैबोरेटरी रे सील्ड कंडीशन तो इट प्रिसपोजेस दैट जहां भी सील हेइतिबो ताकू आईआईसी करथिबो परे रिसीव कला परे अनसील्ड कंडीशन रे रिसीव कला जदी सील्ड कारण वी आर नॉट डिस्प्यूटिंग दैट इट वाज नॉट प्रोड्यूस्ड इन सील्ड कंडीशन बिफोर द C report before forensic science laboratory. ये जो जिनसोडा के एगुडा को आपण ही एक्सप्लेन करिवे प्रोसिक्यूशन ड्यूटी टा जो हमें से डिसीजन टा देखौतिलु जे आपण राइट फ्रॉम द बिगिनिंग आपण को देखिया पड़ियो जे एटा सीज हला परे एटा गोटे एम्ति कंडीशन रे थिला जा देरे टेम्परिंग करिवार स्कोप बहुत नाही तेणु गोटे जिनसो आपण सीज कले एवं दीटा इंडिपेंडेंट विटनेसेस होस्टाइल हो गले केवल पुलिस ऑफिशियल कहला पुलिस ऑफिसर कहूची जे मु ताकू सील्ड कंडीशन करिकिन मो पाखे रखिली तापर मु जेतेबेले दायित्व हस्तांतर कली से लेडी टाकू ताकू गुडा सब देई देली से लेडी को आपण एग्जामिन कलेनी जो दायित्व हस्तांतर रिपोर्ट रे मध्य गोटे प्रोड्यूस करनी जो थ्रू जना पड़ू था एटलिस्ट जे जो पैंटा मध्य गोटे सील्ड कंडीशन रे ताकू दिया आइछि बे तापर देन आपण आनी कोर्ट रे प्रोड्यूस करूचंती से लेडीटा आईआईसी सेठी से फॉरवर्डिंग रिपोर्ट रे लेखा हैनी जे पर्टिकुलर आइटम टा सील्ड कंडीशन रे थिला जदि ओ अन्य केते गुडा को आइटम सील्ड कंडीशन रे लेखा है एवं मजिस्ट्रेट ताकू सेही भली अवस्था रे देई देला आईआईसी बर्तमान आईआईसी गोटे कांस्टेबल जरिया पठेले भुवनेश्वर स्टेट फोरेंसिक साइंस लैबोरेटरी को ताकू प्रोड्यूस करिया आउ साइंटिफिक ऑफिसर लेखचन जे मो पाखरे जेतले प्रोड्यूस हला सेटा सील्ड कंडीशन रे से पैंटा प्रोड्यूस हला तो क्वेश्चन होउची सील कोठी हला किए कला को भली अवस्था रे से प्रतिभा को हैंडओवर करथला सी ताकू केमती रखिला जदि ताकू सील्ड कंडीशन रे देई थांदे ताले प्रतिभा ताकू जेतेबेले प्रोड्यूस कला कोर्ट रे सील्ड कंडीशन नहीं प्रोड्यूस करता ना कि जेतेबेले लिखुची तार फॉरवर्डिंग रिपोर्ट रे जे मु 1 2 3 5 10 एगुड़ाक सब सील्ड कंडीशन ने थिला एगुड़ाक अनसील्ड कंडीशन ने थिला तेणु आमे कहि परिउनी जे इनएडवर्टेंटली ओमिट कर जाइछि बोली आपणकर ऑफिसर इन्वेस्टिगेटिंग ऑफिसर गोटे सी आईआईसी जे की चार्जशीट होइछि सेतेबेले गोटे रिपोर्ट फॉरवर्डिंग रिपोर्ट दउछि ता धीरे 10टा आइटम लिखुछि मु सील करिहिनी थिला आउ 5टा आइटम अनसील्ड कंडीशन ने रखु आमे प्रिज्यूम करि परिबुनी जे नाइ से जो 5टा आइटम टा से जो लिखिछि अनसील्ड कंडीशन रे एटा इनएडवर्टेंटली से मिस करि जाइछि आउ सेटा भी सील्ड कंडीशन ने थिबो कारण कोन ना साइंटिफिक ऑफिसर ताकू देखिछि सील्ड कंडीशन में सो ये जो येटा को आपन को प्रमाण करिया पड़ियो बा आपन को ओवरकम करिया पड़ियो हाउ वी कैन से दैट देयर इज नो पॉसिबिलिटी ऑफ टैंपरिंग विथ कारण आपन देखिले से पैंट रो केतोडा को पर्टिकुलर जगह रे रक्त लागिथिला जोडा को साइंटिफिक ऑफिसर जोटा कट करिसेंती कट कला पर एग्जामिन करिसेंती with reference to that and he found that it matches with the blood group of so and so. 3-4टा जगह रे कटा आइछि तेणु any other submission on this particular pant item रे बड़ा pant item
Purchase रे non produce करे नहीं एमो मार्किंग
हाँ
purchase रे हला
कोडा
purchase रे कट करा कट मार सेरे प्रोड्यूस इन बिफोर द कोर्ट
कट पीस तो सेमाने एग्जामिन कले
होला पर पट्टे जो कटले जहां
हां नहीं
सेटा भी मार नहीं सेटा भी कोर्ट रे मार भा ए पर्टिकुलर पैचेस का
सेमाने कोन पठेइले माने खाली रिपोर्ट का पढो
Page 359 towards the bottom. Page 359 towards the bottom. No.
The portions of the exhibit marked as so and so, received from so and so, were existed during the as those exhibits need not require any analysis and will be retained after the dispatch of the report. The remaining portions of the other exhibits, biology will be retained for a period of 2 months or there's no. No, see the way ये कर दीजिए 2 मास रखला परे ताकू our analysis दरकार नहीं will be retained for period of 2 months after the dispatch of the report. जदि it actually दरकार था ताले आईओ ड्यूटी होची to call for that बा पब्लिक प्रोसिक्यूटर से उड़ा कॉल फॉर करता था सी कॉल फॉर करना थी तेणु destroy ही जाइए सेटा ये So, Mr. Mulia, let us in spite of all these things, if we take into account that appellant number 2's black color pant was, or a black pant was seized at the instance of appellant number 2, and human blood was found, which was of the blood group of one of the deceased, namely Piranchi. And if we give importance to all these things, that this lacuna in the seizure, etc., that's a matter is different. Otherwise, the fact remains that no challenge has been made to the evidence of the IO regarding the seizure and keeping it in sealed cover. And also the questions have been put, 2 questions have been put to you in the 313 statement, and you have simply said that you have not disowned it. Mane je pant more nuhe ba pant taku neikini taku lagei dele tadire amko samko ei sub jinso kichi nahi. So
whether the scientific officer has said anything? No.
Scientific officer,
40.
This man has not been examined.
And you cannot examine. So,
Where is not examined.
But who is 40 then?
in the CFS, district and also to collect the blood sample as from the spot.
They just spot
Spot
test report
from all the 3 spots.
In fact, this report, for proving this report, it is not necessary that the concerned officer should be examined. That is admissible under 293 CR.
Yes. 299 also, let's see, kind of order speed up the additional session.
No, 293 CRPC. Just a minute, let us see.
Consent, there is required consent.
Just a minute. 293. And what? Yeah. पढ़ ले 293 doubt.
Right.
Scientific officer.
The reports of certain government scientific experts, Miller. Any document purporting to be a report under the hand of a government scientific expert to whom this section applies upon any matter or thing duly submitted to him for examination or analysis and report in the course of any proceedings under this code may be used as evidence in any inquiry, trial, or other proceeding under this code. The court may, if it thinks fit, summon and examine any such expert as to the subject matter of his report. Then 3. Where any such expert is summoned by the court and he is unable to attend personally, he may, unless the court has expressly directed him to appear personally, depute any responsible officer working with him to attend the court if such officer is conversant with the fact of the case and can satisfactorily depose in court on his behalf. This section applies to the following government scientific experts, namely A. Any chemical examiner or assistant chemical examiner to the government. B. The chief controller of explosives. C. The director of the fingerprint bureau. So D. The director, Hopkins Institute, Bombay. The director, deputy director, or assistant director of a central forensic science laboratory or a state forensic science laboratory. The serologist of the government, any other government scientific expert specified.
So, Mr. Mulia, it does not require any consent of the Defense Council, like 294. 290. This is a document under 293. Right? That is other documents. Other documents, this is the exception. 293 jo scientific expert or reports, that is different than the other documents which are prescribed that if the prosecution wants to prove and you do not dispute, they will file a list and if you do not dispute, then that can be marked an exhibit. But so far as scientific officers' report are concerned, it is exception. Of course, you can always file a petition that to summon that witness, that expert, and if it court thinks that it is necessary, then he can summon. Otherwise, it is to be marked as an exhibit. So that is how you cannot find any fault on the part of the trial court in marking this document as an exhibit, invoking the provision under section 293. It does not require the examination of the scientific officer.
The only thing with what remains now is tampering cannot be ruled out because of
that is the only thing. Otherwise, baki jinso
admissibility and all, it's all right. Only tampering part.
This exhibit 59, so far exhibit 59 is concerned, Miller. If Lordship see the order sheet of the learned session judge, page 433. 433. All these documents are marked without objection.
Without from the side of the
prosecution, সেটা ভুল করছে।
That is wrong. That is that typo appeal error. Not of objection করে prosecution. Because
that's that
defense.
Will actually file a memo. As you have no objection, you document
no, that is not necessary for 293. There are so many decisions are there. Scientific officers, documents, fingerprint, etc. If you file an application that, let us say, you want to examine a fingerprint expert who has, the court may hear things that can summon. Otherwise, these are all documents say that they stand in a higher footing than the documents which are required to be marked under 294. The separate category of document totally.
Yes.
So yes, anything else so far as this exhibit list is concerned? That is exhibit. It's a one by one.
One by one.
Okay. Now we'll go to the next item. The next seizure list is
one by
exhibit. Exhibit 4. Exhibit 4 is the seizure of Honda motorcycle and one Hapsat. এটা হচ্ছে আরো সেই অ্যাপ্লাইন নম্বর 2 ঠিক তো না হাফসাট পুরো
বানিয়ান এটা হলো ফুল প্রিন্ট থেকে গেল ফুল প্রিন্টের সাথে বানিয়ান মিশছিল বানিয়ান অফ দ্য ডিসিজ সেটা এক্সিবিট এমও 35 এক্সিবিট 10
না না সি যাহা কহিলে
এইটা ফুল প্রিন্ট হইতো ম্যাচ করছি বানিয়ান বেশি সেটা ম্যাচ করছি না তার তার
তার তো ইয়ানি প্রডিউস করলাম মানে পিএম করে দ্যাট ইজ নট না
এক্সিবিট 38 7 and 41
so that is constable anigini pm report so now we'll go to the other seizure list, that is exhibit 4
page 268 is
just a minute. Seizure list exhibit 4 that is in that seizure list it is at page number
268 Milan. Volume 2.
58
268
68
11% 268
66 67 Acha. Oh, it starts from page 267 but 267 268 and
267 it starts.
So one is seizure of Honda motorcycle. The other is seizure of Hafsat. Hafsat. That Hafsat has been marked as MO 24. Right. And it is seized at the instance of
Plan number 2.
appellant number 2. The witnesses you said on that day, PW 4, PW 10 and PW 41 the IO. ठीक तो? अच्छा. वर्तमान सीजर लिस्ट को पढ़े आसंतु
421 and
4, 10 and 41.
4, 10 and 41.
अच्छा. PW4 सपोर्ट करुची. PW4 और PW10 ये जो पर्टिकुलर सीजर होंडा डिलक्स मोटरसाइकिल और हाफसाट आर द इंस्टेंस ऑफ appellant number 2.
Yes, sir.
Para 4 है बोलते.
Just a minute. ये PW4
page 101.
page 109.
101. Para 4.
Pardon.
After 2 days of knowledge occurrence, police seized a motorcycle and one Fakuri, banned and sawdust, actually Ranjal and under this at police station in the presence of myself and Dilip Seth. The police prepared seizure list. This is the said seizure list, murder exhibit 4, and this is my signature on it. Murder exhibit 4/1.
Para 4 page 101. अच्छा एटा को रखी कि बर्तमान सीजर लिस्ट को से पढ़ाई आसंतु 267 रे
Column 5.
Column number 5 on production of plants. नहीं 40 पढ़ाई आसंतु तार नेक्स्ट पेज को कॉलम नंबर 11 circumstance of seizure.
तो मकदमा तंदुर समय रे रंजाल और मंदादी सेठी ता घरु गोटे हीरो मोटरसाइकेल गोटे हाफ सेंट निम्नलिखित बाहर करी ए सब जिनिस को अपराध घटना समय व्यवहार कर दाखल व्यवहार साक्षी मान सामने जबत करा.
तो ये जो आ घरू बाहर करती जे देला बोली ये विटनेस साइलेंट अछि
पुलिस स्टेशन है
होची पुलिस स्टेशन में जबर कला अछि. तो जो सीजर लिस्ट exhibit 4 indicates that it was seized from the house of appellant number 2, but PW4 says that it was produced by police in police station and seized. Okay. This is so far as PW4 is concerned. Now, 10 number Sakivashan.
Page 112.
112. Yes.
Correct.
112. Para 2. Hold on.
The police searched the house of active justice. The almirah and boxes are broken. Later, the police found the dead body of the deceased Viranjanath and Ekalabu. We suspect that due to money of Annapunadu, the accused person might have been killed. The police seized one motorcycle and one half-star in my presence. This is the search list. Already marked as exhibit 4, and this is my signature on it. Marked as exhibit 4/2.
PW et al. Para 2 page 112. PW10 silent that it was seized or the instance of A2, right?
Para 3, cross-examination. I have no direct knowledge regarding the death of this person. I signed the sigil list at Fisher nor case. I cannot say from where the police got the car on the motorcycle.
I signed the seizure list, so I cannot say. Okay. सेमती किसी प्रश्न पचारछन्ते PW4 को ए सीजर विषय ना किसी पचारना थी पचारना
Para
6
कौन
page 101.
हाँ कौन सा
I do not know as to from which place police brought the motorcycle, pursued the pan and such.
अच्छा ठीक है
But the police showed the same at TS. In paper, the sigil is transparent.
all right
I do not know the content of the sigil list.
C cross examination para 6 so para PW4 and PW10 PW4 page 112 cross examination para 3. Now you come to PW41
Page 200, madam.
200
200, paragraph 23,
on a page tag on
page 200, madam. Volume 1.
just
all seizure in para 23 only.
Yes.
Para 2 minor.
Then I examine. Then I examine PWs 1 and 2. Then at 12:45 p.m. I seized the white color half shirt with red, blue, black thin stripes of accused Ranja alias Nandakishore, on which Liverpool has been stitched on the collar, and one red color Hero HF Deluxe motorcycle bearing number OD19K2022 from the house of accused Ranja alias Nandakishore Sethi in the presence of witnesses PW4 and 10, and prepared the seizure list by Exhibit 4 already marked, and Exhibit 4/3 is my signature thereon, and Exhibit 4/4 is the signature of accused Ranja Nandakishore. MO 24 is the said shirt, and a paper slip has been affixed on the packing is marked as Exhibit 55, in which my signature is Exhibit 55/1, and signature of the accused is Exhibit 55/2, and signatures of PW4 and 10 are marked as Exhibit 55/3 and Exhibit 55/4 respectively. I examined PW4 and 10, and then I came back to the police station along with the accused person and the seized articles, and then kept in my custody.
Okay, any questions has been put in cross examination on this seizure of white color upset जो तरह की रेड ब्लू ब्लैक रो तीन स्ट्राइप थिला accused Ranja to Ananda Kishore. So some mark is the work देखियो MO mark is 24 ना 24 का वर्क कोई भी नहीं 24 का बड़े बड़ा 60 तादेरे कोनो रेड और ब्लू और ब्लैक और स्ट्राइप पड़ची upset thing.
Which question 313 pertaining to this?
Not full $1.
Oh, rock. Button Polas on the Mr. Mule, any questions have been put to the IO? Then we'll go to the accused statement. No question. Achara, कितना नंबर को cross examination पहुंचा? A seizure list ऊपर कौन आपको question पहुंचा है? 208.
Yes.
Of the transfer from the agency PW31, he seized one white color half shirt.
Which question?
No. अपन आयो को पास
आयो को बीच पचार
आयो बीच पचार जन no question no question pursue आयो PW41 on seizure list. Exhibit 4. Now we come to the accused statement of appellant number 2.
Question 35.
No, question number
No, it starts from question 32.
accused statement of appellant number 2. Question number kete phone to? Page tag kete phone?
88.
80.
The first one. P4, huh?
41. हाँ
Further transfer from the evidence of legal
नहीं नहीं वो तीन जन जाओ सपोर्ट कले पड़ा सेठी कि ना हॉस्टाइल ये इतला एडी पर तीन जन है सेटा होती 4 टाके प्रमाशन दो
Page 19 to अच्छी देखो. It transfers from evidence P4. On each number page. Question number 2. It was 4 release.
कितने पेज देखो
4 release.
197
19.
190 is it the accused statement of that appellant number 2?
हाँ प्रकाश बेरा.
এটা না নাই এটা প্রকাশ বেরা নাই না না
বাবুলি প্রকাশ বেরা
না না সেটা হচ্ছে appellant number 1
question number 10
এটা হচ্ছে appellant number 2 that starts at page number 216 216
It is at page
এটা হচ্ছে appellant number 1
Question same regional.
না সেটা মানে এটা
216
216 বার পেজ হ্যাঁ এটা হচ্ছে রঞ্জন আর হচ্ছে প্রথম হচ্ছে কোশ্চেন নাম্বার
10
আচ্ছা
50
Question number 10. Transfer evidence of one of 2 days of police seized motorcycles on sir. Yes, in his presence along with the presence of so and so at 9. अच्छा तापरे गला क्वेश्चन नंबर 10 आउस 8टा जो कोन
10
10 नंबर साक्ति रो केते क्वेश्चन
question 35
क्वेश्चन नंबर 35
60
page 58 and question number 35 page 62 अब बाकी रहला आईओ क्वेश्चन नंबर 23 सीजर लिस्ट ऊपर
question 208 question number 208 page 88
208 अच्छा He seized half shirt अच्छा on which Liverpool has been stitched on the ऐसा लिखा है Liverpool वाली
लिखा है leaf full question
अच्छा क्वेश्चन नंबर 208 पेज नंबर 88 सब नहीं
Liverpool Question is leaf full.
Leave full.
ହଁ ଯାହା ଆଇଓ କହିଥିବ ନା ତା ଉପରେ କ୍ୱେଶ୍ଚିନ୍ ହେଇଥିବ ଆଇଓ କ'ଣ କହିଛି ଏବେ ପୁରା ଦେଖେଇଲା ଆମର ଲିଭରପୁଲ ଲେଖା ହେଇଛି
Leave full.
ହଁ ସେ ହଁ ତ ବାକି ତ ଏଇଟା ହେଇଗଲା ଫ୍ୟାକ୍ଚୁଆଲ ଆସ୍ପେକ୍ଟରେ ବାକି ଯୋଉ ଇଏ ଗୁଡାକ ସେମ୍ ଇଏ ଯୋଉ ପ୍ରଡ୍ୟୁସ ହେଇଛି ଯେତେବେଳେ ମୋଟର ସାଇକେଲ ଛାଡି ଦିଅନ୍ତି ଯୋଉ ହାଫସାରଟା MO23 ସେଇ ଟାଇପର କଣ୍ଡିସନ ସେଟା ସିରିଏଲ ନମ୍ବର କେତେ ଫରୱାର୍ଡିଂ ରିପୋର୍ଟରେ
Page 345, serial number 30.
345 item number 30 na so forwarding report page 345 serial number 30 बाकी तार येटा फाइंडिंग टा आसला कोठी कौन बाहर लगा जरूर conclusion
Page 359.
serial number कितने full plant अच्छी caught piece from globe अच्छी କିଛି ମିଳିଲାନି କି
Not much.
ହଁ ସେଟା କେତେ ମାର୍କ ହେଇଛି ରୁହ ସେଟା ହଉଛି exhibit Q-1 Q-1 ରୁ କିଛି ମିଳିଛି ନା ନାଇଁ ମିଳିନି ଲେଖା ହେଇଥିବ ଯେ ଏଇଥିରୁ କିଛି ମିଳିଲାନି ବୋଲି Q1 set mark ହେଇଛି କେତେ
Cut piece from the start of the deceased.
No, start of the deceased. It was start of the accused. Appellant number 2.
Oh, I could have been in a boy. Isn't it? Cut piece start from the accused above. Table 3. Cut piece of whole deceased now caliber.
No,
କିଛି ନାହିଁ there is nothing.
କାହିଁକି ନା ଏଇ ଯୋଉ ଆପଣଙ୍କର ଏକ୍ଜିବିଟ୍ ମାର୍କ ଗୁଡାକ ଆପଣ ଦେଖିଦିଅନ୍ତୁ ଏଇ ଯୋଉ ଗୁଡାକ ମାର୍କ ହେଇଛି ଉପରେ ପେଜ 352 ରେ ସେଗୁଡା ସବୁ ଲେଖା ହେଇଛି
351.
251 30 ହଁ ନାଇଁ ସେଟା ତ Q1 ହିସାବରେ ମାର୍କ ହେଇଛି ସେଟା that is very clear ହେଲା ସେ Q1 ର ଫାଇଣ୍ଡିଂ ରେ
Conclusion
ବେଳେବେଳେ ସେଟା ଲେଖା ହବା କଥା ଯେ nothing was found from
result of exam 362 ଦେଖନ୍ତୁ ଏଟା full set କିଛି ନାହିଁ
ଓହୋ କେତେ କେତେ ପେ
362 362 serial number
ହଁ ଏଠୁ କିଛି ବ୍ଲଡ୍ ନାହିଁ ଆଚ୍ଛା
30
Okay. Excellent.
C is about 30.
Okay.
No block. No block.
C report. এটা কেতে মার্ক ହେଇଛି ସେଇ
Sir,
exhibit
part, sir,
এটা সেপারেট মার্ক
No,
না
separate
নাই
these are
সেই তারি পার্ট আছে exhibit C report page 362 indicates that from Q1 no blood was found. Q1. Okay, ବାକି ତାପରେ ଆସନ୍ତି ନେକ୍ସଟ ହେଲା ଆମର exhibit 19 seizure of gamucha and cutlery at the instance of appellant number 1 ଆପଣ ୱିଟନେସ୍ କହିଥିଲେ ସେଦିନ 11:35 ଆଉ 41 ଠିକ ତ ଆଚ୍ଛା your list exhibit 19
page 291.
seizure list ଅଛି
Aye.
volume 2 ରେ
Volume 2.
volume 2 page number 291 seizure of gamucha MO mark ହେଇଛି VII ଆଉ ଗୋଟେ ହଉଛି କଟାରୀ mark ହେଇଛି MO6 ଠିକ ତ 6 and 7 ଆଚ୍ଛା seized at the instance of appellant number 1 under section 27 of the Evidence Act and witnesses are PW 11 PW 35 or PW 41 so seizure list ଆସିବା so ଏକା ଲାଗେ place of seizure पढ़ंतु 5 number column
From the cultivable land of Boiragi Naik of
food
village
पढ़ हाँ ठीक
of village Pokonda.
5 number
5 number.
from the place
From
of
the place of concealment on production by the accused Babuli alias Kokas Behra.
अच्छा बर्तमान दीटा विटनेस अछंती गिरीश चंद्र नायक पीडब्ल्यू केते हाँ
3511.
नहीं गिरीश चंद्र नायक टा केते
35.
पीडब्ल्यू 35
15
Vipin Naik is PW 11.
अच्छा
His statement is at volume 1 page 114.
okay and what was seized number 1 अला
ଗୋଟେ ଲୁହାର କଟୁରୀ ଯାହାର ଲମ୍ବା 36.5 cm ଉପର ଓସାର 5.5 cm ମାଟି ଧାର ଚଉଡା 4 cm ତଳ ପାଖ ଚଉଡା 3.5 cm ରକ୍ତ ଲାଗିଥାଏ 2 ଗୋଟିଏ ପୁରୁଣା ରକ୍ତ ଭିଜା ଗାମୁଛା ଧଳା ରଙ୍ଗର
ଆଉ କଲମ ନମ୍ବର 11 ଟା ପଢନ୍ତୁ
During investigation of the case seized as the accused led the police team and witness and show the place of concealment in presence of witnesses in noted on column number 6.
अच्छा and you see item number 8 serial number kept at PS Malkhana पाइले serial number 8 अच्छा वर्तमान एविडेंस को पढ़ाया सुन PW 11 के को पेज रे कहछि विषय हां
114
କୋଉ ଲାଇନଟା
Alert,
ଆରମ୍ଭ ହେଇଛି?
on 12-10-17
ଓ ଆଚ୍ଛା ଆଚ୍ଛା ଏଇଟା
paragraph first.
ହଁ ଫାଷ୍ଟ ପାର୍ଟ ପଢନ୍ତୁ।
The accused Prakash Behera and Nanda Kishore Sethi confessed their guilt. The accused Prakash Behera stated before us that the deceased Biranchi Naik,
Prakash is appellant number 1.
appellant number 1.
Yes.
Biranchi Naik had obtained loan of Lakhe 75,000 and therefore both the accused person had planned to rob the deceased. He also stated that he, along with the accused Nanda Kishore Sethi and deceased Biranchi, went together and he cut the throat of deceased Biranchi by one chopper. Then they went to the wife of the deceased Biranchi and also killed her by the chopper. Then they took the son of deceased and killed him near
These are
Pokonda.
all inadmissible.
Therefore,
Next.
he
Therefore,
stated
he
to have
stated,
concealed.
This is important.
This part is. Therefore, he stated to have concealed the said chopper and blood-stained towel near a bush. He also stated to have concealed his wearing apparel by digging a ditch near Brahmanapada. Thereafter, both the accused person led us to the place of concealment, that is the land of Boiragi Naik at village Pokonda. On the same day, at 9:30 a.m., the police seized the chopper and one blood-stained towel on production of the accused persons in our presence. This is the said confessional statement of the accused Prakash marked as Exhibit 18, and this is my signature on it marked Exhibit 18/1. This is the said seizure list marked Exhibit 19, and this is my signature on it marked as Exhibit 19/1. Both the accused persons also signed on the seizure list in our presence.
Anything brought out in the cross-examination, Mr. Mulya, on this seizure?
it is only the accused brought out the chopper and towel from the bushes.
Next
and
page,
handed over.
116. Handed over
Only.
the same to police.
Only
Appellant number 1.
That is also the. Both the appellant are signed on seriousness.
No, that is, but that might be fault. It should have been only because it was seized at the instance of Prakash only, and then they went to this one, so killed us one. Therefore, he stated to have consoled. He also stated. Both the accused led to the place of concealment of Vairagi Naik. On same day at Swanso, police seized production of the accused person. This is the confessional statement, Swanso. तो चीफ एग्जामिनेशन ने कहला जेते उभय अक्यूज कन्फेशन कले इट्स ए जॉइंट कन्फेशन एंड देन से माने नेकी गले से माने नेकिनी तापरे प्रोडक्शन ऑफ द अक्यूज्ड पर्सन्स चॉपर और टॉवेल जबत हला why you put such question in the cross examination that it was the accused brought out in the chopper and towel? No question. It should not have been put. Rather, it should have been shown that the seizure list indicates that it contains the signature of general question that jaha to ja instance re jabat kara jaye तार सीजर लिस्ट रे दस्तखत निया जाए आपण दस्तखत देखौछि जे आपण दी जनकर दस्तखत नै छथि और दी छाड़ दी था ताको ए जिनस पचारि किनी क्लारिफिकेशन आनथले
Specimen of seal is given with it. It is blank.
That we know, that is, we have taken note of it. Specimen seal, but one thing is that police malkhana rakila boli seta mention is seizure.
No malkhana number is.
That is those we have noted down, that malkhana. What about the other witnesses, PW?
Page 164, volume
35.
164,
Last line.
paragraph 2.
Last line.
After
Babuli
commission of
disclosed.
murder, he kept in hiding the blood-stained gamucha along with one kotuni at a distance of 100 meters from the place of confession. Babuli also confessed that he kept in hiding his blood-stained pant and shirt at Brahmanapada Nola project. Then Babuli disclosed before the police that if he will be taken to that place, 2 places of hiding, he will give the recovery of the offensive weapon used by him. So also the blood-stained cloth, which includes gamucha, 1 pant, 1 shirt, police recorded confession statement that after such recording, Babuli led the police along with the witness to the place of hiding to give recovery of offensive weapon and the blood-stained cloth, which include gamucha. Then police along with the witnesses moved to the spot and accused Babuli gave recovery of blood-stained gamucha along with the koturi from a Bounce Buddha of Boiragi Naik. Police took the measurement of koturi and the length of the koturi would be around 14 inch to 15 inch long. The koturi was completely prepared from iron and there was no such wooden handle. I can identify the said koturi if will be produced before me.
Any questions have been put? No questions.
Allied only smilers would actually confess the guilty at the place of confession than the police station. I cannot say from which place the police have come.
Questions means anything brought out in your favor.
No, man.
Question.
And these 2 articles were not
Only one
sealed.
smile, para 11 minor.
It is not sealed. That is comment. Para 6.
Para 11 minor.
Kahar para 11.
35.
Kौन कोई?
The road nearing the place of recovery is also used by public.
ଏଇଟା ପୁରା ବୁସ୍ ପାଖରୁ ବାହାର କରିଦେଲା ଆପଣଙ୍କର
road nearing the place of recovery is also used by public. Para 11 last time.
No, you see, it may be an open place, but if in that open place it is kept in such a place that the persons ordinarily going in that road would not able to see it, then that is also admissible. ତେଣୁ ଗୋଟେ ନର୍ମାଲ ପ୍ଲେସ୍ ହେଇଥିବ କିନ୍ତୁ ଗୋଟେ ବୁଦା ଭିତରେ ନୁଚା ହେଇକି ରଖା ହେଇଛି, ତେଣୁ ଏଠି ଆପଣଙ୍କର ଯୋଉ ଇଏଟା ଯୋଉ ସିଜର ଲିଷ୍ଟଟା ପ୍ଲେସ୍ କଲେ ସେ ସିଜର ଲିଷ୍ଟ ଦେଖଉଛି ପୁରା କେତେ ନମ୍ବର ସିଜର ଲିଷ୍ଟ ଏଟା ଏକ୍ଜିବିଟ୍ 19 पेज नंबर होची 291 प्लेस ऑफ कंसीलमेंट होची ड्यूरिंग इन्वेस्टिगेशन द लेट्स आल्सो वो गुडा जगत
from the cultivable land of Boiragi Naik of village Pokonda.
From the place of concealment on production of it.
Cultural land, not bush.
କୋଉଥିରେ ଗୋଟେ ବୁସ୍ ଲେଖା ହେଇଥିଲା ଆର ସିଜର ଲିଷ୍ଟର ବୋଧେ ଏଇଟାର ଅବଶ୍ୟ ବୁସ୍ ଫୁସ୍ ଲେଖା ହେଇନି ହଁ ଏଇଟା ଆଚ୍ଛା ଆଇଓ କୁ ଆସିବ ଆଇଓ ଆଇଲେ ଜଣା ପଡିଯିବ
This is important 166 it was not seen
ତାପରେ ଆଇଓ ପଳେଇ ଆସନ୍ତୁ ପେଜ PW41 PW41 ର ସେଇ ଏଇ ଯୋଉ ସିଜର ଲିଷ୍ଟ ଉପରେ ତାର ଏଭିଡେନ୍ସ କଣ
Page 190.
Achha, whether that statement has been marked as an exhibit?
Yes,
That's 27 statement. Exhibit 8. हाँ, सही था कौन? ये जो आईओ को इस समझ लो? हाँ, ठीक है. आईओ पढ़े सुन.
आईओ था 27 statement विषय कोई ची page 197 ने में.
ये जो एक particular seizure list रा पूर्वरू.
आगे exhibit 18 ने.
197.
आगे.
कोको उनको लाइन डाक.
मिलन. He further stated.
No, cool line.
I obtain the signature of Prakash and so and so, and this is practicable. I give.
Then I recorded the statement under section
27.
27
of the Act has been marked as Exhibit 18. And Exhibit 18 by 5 is my signature thereon, and the signature of accused Babula on Exhibit 18 is already marked as Exhibit 18 by 3, and the relevant portion of the statement of the accused Babula has been marked as Exhibit 18 by 4, already marked. At that time, other witnesses along with accused Ranja were also present. After recording of Exhibit 18, accused Babuli led to the first place where the incriminating weapon of offense along with the napkin was lying inside the bamboo bush, which was inside the cultivable field of one Boiragi Naik, which is a jungle area. Then accused produced the weapon of offense MO6 and the napkin MO7 in the presence of witnesses PWs 11 and 35, and then prepared the seizure list filed Exhibit 19, already marked, and Exhibit 19 by 5 is my signature thereon.
ଗାମଛାଟା ବାହାର କଲ MO7 ଆଉ କଟରୀଟା ବାହାର କଲ MO6. Any questions have been put to the IO on the seizure list, Mr. Mulia? Exhibit 19 occurrence.
Only one formal question was put to the IO.
General question.
General question, that is at page 206, 44. General question.
204.
44. 206 million.
206.
Again. 44.
Number 44.
Suggestion. And also at page 205. 7.
One is similar amount available in Costco.
Responder. अच्छा अब आउटा सातटा गामछा रखिदियो बर्तमान फाइंडिंग आसंतु ए जो की रिपोर्टर फाइंडिंग गामछा रो फाइंडिंग तक
359. 6 madam.
359.
Conclusion 6.
6. Take your own. Report.
The DNA profile.
Page 359. Serial number 6. Pardon.
The DNA profile generated from exhibit marked O, caught fish from napkin of accused Babuli, alias Prakash Behra, with the dropout at DYS 391 locus, referred to and so, is of a human male origin. At 23 numbers of lossy DNA profile exhibit M1 caught fish from shirt of which is Nobo Ecolobionite is matching with DNA profile generated from exhibit marked O, table Roman 4.
তাহলে নাপকিন রে ইয়ার গামছারে যে ব্লড সেই ব্লড মিলিলা ডিসিজ নবর শার্ট র সাঙ্গরে ম্যাচ করছে এয়া তো
and also let's see
how one
find it at page 357 point number 5 million
357 point number 5 ସେଇଗୁଡ଼ା सेम थिंग तो कंक्लूजन रे ताकू इट इज स्कैटर्ड हेकिन अछि एठी कंक्लूजन रे
actually page 354
कोन है
you know the comparison DNA profile of the exist mark as O with KL1 M1 the column rank serial number 11 का देखो DYS 391 blank है
No, no, it is not necessary that everything should match, but DNA ର କେତେ ଗୁଡାକ ଇଏ ଏଠି ମେଜର ଜିନିଷ ଗୁଡା ମ୍ୟାଚ୍ କରୁଛି। ସେ ଗୋଟେ ଜିନିଷଟା ଖାଲି ଇଏ କରୁନି, ବଟ୍
ଯୋଉଟା କହୁଛନ୍ତି ଡ୍ରପ୍ ଆଉଟ୍ DYS 391 ଲୋକସ୍ ଯୋଉଟା ପାରାସିସ୍ କହୁଛନ୍ତି ସେଇଟା କଲମ୍ ଟେବୁଲ 4 କଲମ୍ରେ ସିରିୟଲ ନମ୍ବର 11 DYS 391
ଏବେ ନାପକିନ୍ ହଉଛି ପ୍ରକାଶଟା ହଉଛି ଫାର୍ଷ୍ଟ କଲମଟା, ଏକ୍ସିବିଟ୍ ଯୋଉଟା ମାର୍କ ହେଇଛି ଓ ହିସାବରେ
11 DYS 391 ଯୋଉଟା ବ୍ଲାଙ୍କ ଏଠି ହେଲା ଏକ୍ସିବିଟ୍ L1
ଟା ହେଲା କଟ୍ ପିସ୍ ଅଫ ବ୍ୟାନିୟନ ସୋ ଏଟା 10 ଟିକେ ଟିକେ ଆସିବ ଫାଇଣ୍ଡିଂଟା ଆସିଲ ଆଉ ଥରେ ପଢନ୍ତୁ।
DNA profile generated from exhibit mark O actual Babul Prakash drop out at DYS 391. DYS 391.
Acha is of human origin and at 23 number of so exhibit M1 cot piece of deceased is matching with
Table 4 or 11. Table number 11.
Serial number 11. वो ड्रॉप आउट मैच गलानी केमती लिखदेले रिपोर्टटा ये देखंतु आ फिर सबमिशनटा देखंतु सबमिशनटा देखंतु आगे पेज नंबर 354 को पळे आसंतु 354 रो टेबल होची आईवी हैला आईवी रो जो थर्ड सीरियल नंबर पळांतु एग्जिबिट मार्क एज ओ cut piece of napkin of accused so and so हैला तापरे exhibit को पढ़े आसंतु M1 cut piece of shirt of deceased napkin of so and so आर चाहे मैच कला बेली drop out आउच important वर्तमान 6 को पढ़े आसंतु जो टी अपन लेक्चर दी finding DNA profile generated from exhibit marked as O Hala, with dropout at DYS 391 locus is of a human origin and at 23 of low C DNA profile of exhibit M1 is matching with DNA profile generated from so-and-so. At the DNA profile की जोना पुरनी तर matching केम दिखेगा ताटा उसी
conclusive अच्छी ना फिर भाई क्या कंप्लीट It is 362. Conclusion 362. Conclusion. This one. So, no, right. Oh, Lord, no opinion, inconclusive. It is here. Panian. Right. L1 था ना कितने ना कौन पिला?
एटा मार्क ही ची M1 है।
M1
गोटे M1 गोटे O.
M1 देखो M1 same M1 रहे. No opinion, inconclusive.
Human, no opinion, inconclusive.
There's nothing definitive.
So these are so far as the seizure list exhibit 19 is concerned. Our good seizure list will allow. So we'll take it up on Wednesday, right? That is our good seizure list. Kitna number था
21. 21.
21 ଟା रहला सेटा ई कला परे आपण कंक्लूड करिवे आर्गुमेंट the reply देवे then we will hear about this date aspect, right? अच्छा, ये प्रकाश बेहरा आउ ये नंद किशोर सेठी एंड मिस्टर एडवोकेट तो आज ये सुनानी तो चलला और बाकी आपण माने जो एफिडेविट देइतिले हमर जो 18/6 ऑर्डर अनुଯାयी ताको आमे रेकॉर्ड रखिलु आउ सरकार मध्य हमकु जो कुआइतला रिपोर्ट से मध्य रिपोर्ट देइचंती से सब आपणकर कन्विक्शन पूर्व आपणकर जेल भितर को टाइप आचरण थिला जेल कन्विक्शन परे कौन आचरण रहिला आपणकर साइकोलॉजिकल कंडीशन मनो ये विषय अन्य जिनस सब देइचंती तार कॉपी आपणकर वकील मूल्या बाबू पाखे अच्छी जदि सी आपन को ये करेंगे ताकू देखी तापर जहाँ कहवा कथा आप पारती जदि किसी लेखिक देवे दे पारती जदि किसी आपण विरुद्ध रे थाए बाकी शुणाणी रहिला 2 तारिख दिन 2टा बेले पुणी हम है से दिन आपन 2 जन रे एडवोकेट बाबू भी रे दिन एनश्योर करेंगे से टाइप ऑर्डर करदे है हाँ हाँ एमओ गुड़ाक खोला स्टेट एमओ कही है गुड़ाक पुणी सील कवर रखा है ना।